efforts today and tomorrow. We've invited representatives of each of those groups because we hope to have a conversation about the Big Horn process, about the outcome, and about the future. That this conversation should take place in the heart of the Big Horn Basin and on tribal lands seems very fitting to us. The Eastern Shoshone and Northern Arapaho tribes have invited us on their lands for the purposes of these meetings, and we're enjoying the hospitality of the Northern Arapaho tribe in this beautiful convention center. For these reasons that I've just mentioned, and because of the huge importance of the Big Horn to the tribes, the steering committee, the Big Horn Symposium steering committee, decided to invite each tribe to offer an opening prayer. So, we are very honored to have with us this morning Mr. Nelson White Sr. of the Northern Arapaho tribe and Mr. Filbert McLeod of the Eastern Shoshone tribe. And these gentlemen enjoy the great respect of their peoples. Each will offer a prayer to bless and guide what we do today and tomorrow. So, if I could have quiet, and if anyone who's not seated, if you could just stand for a few minutes, I'll turn the stage over to Mr. McLeod and Mr. White, and I'll let them decide who would like to go first.
Thank you very much. I want to welcome all of you to the Big Horn Symposium. I was very happy to say a prayer for the symposium. I was invited by Mr. Sinclair, and I was very happy. You know, the Indians, we pray for this water all the time. My grandma's, my grandpa's, when I was still a child, taught about this water, the prayer that goes with it, the life-saving prayer that water has. I still use it today. I pray all the time. When I was overseas in Vietnam, I prayed on that water too. Prayed for the soldiers, my friends. I even prayed for my enemy, that we won't hurt each other. I prayed that way, the water. And I was blessed. I come home alive. I was wounded. And but I saved a lot of people over there. I was a machine gunner, and the Army gave me the Distinguished Flying Cross for being a gunner. I didn't do nothing to earn it. I just did that to save my own life and save the lives of my crew members and the lives of the soldiers on the ground. So I did a lot of shooting with my machine gun. And we crossed the big water, come home again, still praying. And I was very happy to hear that we're going to have a symposium here on our land, the Indian land. You know, our leaders years ago, Shoshones, they talked with some soldiers over our treaty, over this water, our land, and all the education that we can have. It's still in the works today. We live under it. And it's the prayers that they said over this water that makes that possible. And today we're going to continue that. I want to thank all of you for showing up and make the Indians feel good. mal McNui European and Baby Jesus, if when I go Subia Val, when I go Savicho, let me answer to you. Number we go on to me, sometimes. You can put a fire, agents of Bible like Mamma Jawago. And the bar in Mishuntain. San Hina could in Mishuntain. Hina doesn't down the Toranway. Came a Suman. Sukarman, Sinasango, Rassandaman. In the rest of them, Heinz, Agent Ivo, Women's Waters, and ik heb bij mama weekend. Ik heb nieuwe soep van de mijn bara. Zo ik me zoente. Zo ik nieuwe soep kan die zoente. Ik kan niet dat te gaan. Niet mijn handje saai gaan. We moeten zo rest maar zoente. Zeggen we moeten zo rijden bij zo bij. Zo kunnen we niet goed bij zo bij. Zo kan je wat doen. Ik kan me zo persoonlijk. Nemen tego op de zonten. Zo ik heb Congress rijboor. Ik heb wel eens in de rijboor dat is de meer mooi gaan. Ik heb bij in de Surinamers de zonten nu. Zo ik de zonten naast doen bij Jesus zo weer. In bar. Hoe we gaan? Thank you.
I want to say, thank you for asking me to pray before getting started on this symposium over water. I'm glad to do that, you know. This morning when I came out, it was raining. It's a blessing, the way I take it, you know. We're getting together here. We need to continue to work together, help one another. And I'm gonna say a short prayer that was used by my elders. So I'm going to say again, thank you. I want to thank McLeod here for his prayer, you know. Thank you all for being here. O my Father, Holy Spirit, four old men, sacred pipe, morning star, and all good things of creation. I mention these good things: the light of dawn, the good wind, the timber, the soil, the animals. Listen, all you creatures under the ground, all you creatures above the ground and in the waters. May this people be long in life and increase. May our boys and girls, our children of all ages, may our grown men and women and all our elders, may they increase and be strengthened. Our Father, Creator, we ask this blessing upon our food. We ask for all your people to the increase of loving hearts and the happy life of peace and harmony. And I say to the Holy Spirit, the Creator, and I say to you all.
Okay, on with our program. Yes. Does it have your name? Okay, right, good. Many people contributed hundreds of hours in planning this symposium. We'll introduce many of them before the program is over, but my colleague, University of Wyoming law professor Jason Robeson, did more than any other single person to make these plans of ours a reality. So, it's my pleasure now to introduce Jason. You'll see more of him over the course of today and tomorrow, but for now he's going to give us a sort of a roadmap of where we're going. And thank you very much for all being here.
Thank you, Dad. I echo my colleague Deb Donahue's thanks for the tribal elders coming out to begin the symposium on tribal land. We greatly appreciate their taking time and beginning the program that way in this place. The planning process for this event dates back to about a year ago directly. There has been a steering committee of 10 people who have been involved in envisioning and executing the event since we began. They'll be named by my dean at the close of these proceedings, but I mention them now to say that sitting up here, looking across this room at the high attendance and the caliber of people that we've been able to attract, I'm grateful to all of you for your interest in this event and amazingly pleased to see such a good thing have come together. Two things are really the focus of my initial remarks. I want to begin by offering an overview of the program as a whole. I won't go into too much detail and bore you to death, but I want to provide a sense of where we'll be going over the next day and a half. After doing that, I'll have the pleasure of introducing the keynote speakers for our opening panel. They are threefold. With regard to the program as a whole, agendas for the program are available at the table in the back. Much thanks to Christine and Kelly. You can also get copies of the agenda online. Overall, we're dealing with a day and a half of programming. Today, we'll focus on the adjudication primarily from a historical perspective. We're going to begin with an initial panel that focuses on the history of the adjudication itself, legal history of the adjudication itself. That panel will be preceded by remarks from Special Master Ramsey Kropf. The Special Master will then step into the moderator role and moderate the panel for roughly an hour and a half shortly before lunch. At that point in time, after we've canvassed the legal history of the Big Horn General Stream Adjudication, we'll consider where it fits within the American West as a whole. That is, we will compare and contrast it with general stream adjudications that have occurred in 4 other states around or contemporaneously with the Big Horn adjudication. Those states are Montana, Idaho, New Mexico, and Arizona. We'll have a comparative panel that will be preceded by remarks from Federal Water Master John Thorson, describing the general pattern of general stream adjudications across the West over roughly the past 4 decades, and we'll then delve into the panel itself, which will be moderated by Federal Water Master Thorson. After the 2 indoor sessions, the retrospective one that's more focused within the state and that more focused on a regional level, we will, or at least some of us, will leave this facility and we will be taking a field trip to the Ray Canal system that would be led by the Northern Arapaho Liaison, Gary Collins, and members of the Tribal Water Engineering Department, Baptiste Weed, and Jim Pogue. Seating is limited for the field trip. Please be aware of that. If you're interested in attending, there's a sign-up sheet again at the registration table, but seating is limited. I might also add that the forecast does not look like it had us in mind as far as this field trip goes. I lived in Oregon for 10 years, so this doesn't bother me, but for those of you who might be averse to rain or, I dare say, snow, you'll want to bring a jacket if you'd like to go out in the field. That excursion will be 3.5 hours in length. We'll leave around 2:30, give or take, and come back around 6 o'clock. Tomorrow, we'll be looking forward rather than looking backward. Most of what I've said with regard to today's program is, again, retrospective. Tomorrow's focus will be more prospective. What comes next? And what comes next in two respects is the main focus. First, what comes next in the basin, this basin, after entry of the final decree. That will be the focus of an initial panel led by Ann McKinnon. And secondly, we'll also look at what comes next with regard to the role played by general stream adjudications in Western water management from a regional perspective. What role do these proceedings have throughout the American West going forward? I will moderate that panel. The closing speaker we're fortunate to have is a member of the Wyoming Judiciary who has had more involvement chronologically in the adjudication than any other, and that's Judge Gary Hartman. He will offer closing remarks, but his counterparts on the front end of the program are going to be seated next to me in just a moment. They are threefold: Jennifer Gimble from the U.S. Bureau of Reclamation, Pat Terrell from the State Engineer's Office, and John Washakie from the Fort Washakie School. If I could ask those individuals to take seats to my right here, I will then offer proper introductions. Thank you. Thanks, John. Please. Actually, it's okay. Everyone has a chair. All right. I'm going to introduce our opening keynoters in alphabetical order rather than the order in which they're seated. The speaking order, we will have Pat Terrell, State Engineer, speak first, John Washakie second, and Ms. Gimble, Jennifer Gimble, speak third. But as far as their backgrounds, their write-ups are in the program materials. I'll start with Ms. Gimble. Jennifer Gimble is the Bureau of Reclamation's Deputy Commissioner for External and Intergovernmental Affairs back in the Bureau's D.C. office. She assumed this position in March 2014. She, in that position, oversees Reclamation's congressional, legislative, and public affairs activities. True to the title of her position, she's interested in intergovernmental affairs. Jennifer grew up in Wyoming, Cheyenne specifically, and has held a number of positions prior to her position with the Bureau of Reclamation, including Director of the Colorado Water Conservation Board and positions with both the Colorado Attorney General's Office and the Wyoming Attorney General's Office. I might also add that we're proud to include Jennifer as an alum of the University of Wyoming College of Law, actually a two-time alum. I believe Jennifer did her undergraduate and her JD work at University of Wyoming. So, Jennifer Gimble. Next, we have the state engineer, Patrick Terrell, Wyoming native, who, like Jennifer, also grew up in Cheyenne. Mr. Terrell assumed the state engineer position in January of 2001. In his role as state engineer, he wears many hats. He's the representative for the state of Wyoming on the Upper Colorado River Commission, as well on the North Platte Decree Committee, as well on the Colorado River Basin Salinity Control Forum, and finally, also on the Western States Water Council. Prior to serving as state engineer, Mr. Terrell served as Wyoming's commissioner to the Bear River and Yellowstone River Compact Commissions. I'll also close his introduction by saying that we're proud to have him as an alum of the University of Wyoming, specifically University of Wyoming College of Engineering. And on the far end of the table, we have John Washakie. John Washakie is the great-grandson of Chief Washakie, the individual who entered into the Fort Bridger Treaty of 1868. John's background is extensive, like those of our other panelists. Served 9 terms on the Shoshone Business Council, also served as chairman of the Shoshone General Council, had involvement in the Big Horn General Stream adjudications in those positions of different forms, including attending the special master proceedings shortly after the adjudication commenced. Mr. Washakie, like the other 2 keynoters, is also a University of Wyoming alum. His degree is from the History Department, Department of History. He's also an author, stemming from that, of 2 children's books and 3 self-published stories. So, needless to say, we feel very fortunate to have gotten people of this caliber to agree to serve as our opening keynoters. We're extremely grateful. I have no doubt that the things they have to say will be very enlightening, very thought-provoking, and without further ado, I'm going to hand over the mic to State Engineer Pat Terrell. Thank you.
Thank you, Jason. Appreciate it. Good morning. What a wonderful rainy day to spend in Riverton and on the reservation here in central Wyoming. We should have more meetings if it makes it rain. This meeting and the decree signing that happened last Friday was a long time in coming. 37 years to complete 3 phases and 7 Supreme Court cases. I think the logical question at this point then is, what have we accomplished? First of all, probably a major accomplishment of the general adjudication is that we have removed doubt about what the tribal and federal non-tribal rights are, their priorities, and how much water they represent. That's a big deal. We cleaned off all the books in Water Division 3 on unused and unadjudicated rights that existed prior to 1984. That's another big deal because no other water division in the state of Wyoming can say that. We have paper rights in Divisions 1, 2, and 4 that could use a similar cleaning up. Let's look briefly at what the general adjudication accomplished. Phase 1 quantified the tribal right with 290,000 acre-feet of current and historic uses with a priority of July 3, 1868. It also awarded 209,000 acre-feet of futures awards for 5 identified projects that have yet to be built. The 500,000 acre-foot awarded was for approximately 108,000 acres, or overall, the water duty on those acres was about 4.6 acre-feet per acre. The appurtenancy decision in 2001 that attached awards to lands attached over 158,000 acre-feet of that right to 28,000 acres for a duty of over 5.5 feet of water. That's a lot of water. When you look in the North Platte Basin and people get 1.5 feet or 2 feet of water, and you see an award or rights in this valley that get 4 or 5 or 5.5 feet, I would say that's pretty significant. Phase 2, the federal non-tribal awards, recognized all kinds of federal rights, including some in Yellowstone Park, wells and reservoirs on BLM land, discrete water uses, and point in-stream flows on the Shoshone and Big Horn forests. Then we come to Phase 3, which dealt with over 4,600 state permits for reservoirs, ditches, and enlargements. Over 10,000 wells were also evaluated. Many of those were stock and domestic and didn't need a lot of work, but around 500 wells were adjudicated for larger uses. Since Phase 3 only dealt with those rights that were unadjudicated as of the end of 1984, the universe of those was about 30% of all the rights in Water Division 3. That's still a lot. Where there were Walton or tribal overlaps with any of those state rights, the underlying state rights were canceled or eliminated. In recent years, I think our relationship with both the tribes and the federal government in Division III has been as good or better than at any time during the litigation. Partly that's because when you're in active litigation, relations are understandably tense. Now that we have a final decree, the time has come to roll up our sleeves, combine our efforts, and make the general adjudication and the court decisions work. Going forward, what are the issues? Number one, it's communication, and I'm very pleased that we are starting that with a meeting much like today, Closer communication among all parties will be incredible. A system. State rights, tribal rights, federal rights, all together. In recent years, even under the decisions that came down in the 80s, we've been able to do that. And that needs to be recognized. I would congratulate the Office of the Tribal Water Engineer, our Division III offices, and the federal representatives on being able to get that coordination and administration done. But I refuse to believe that things can't get better. They always can. The minute you think that they can't, you've lost. So how do we get better? Data sharing between the states and the tribes, coordination on administering a river system that includes sometimes 3 or 4 different types of rights in the same. We have volumetric awards and we have rate-based awards under state rights. The best way to avoid future misunderstandings is to sit down together a whole lot more. What does the future look like? In other ways, there are probably 2 major themes or 3 that I can see coming out that will be major discussion points during this conference, and I'll just mention them. Number one is this ongoing administration. How do we continue to talk? How do we continue to account for, monitor, regulate, deliver the water that people need? And I think an ultimate goal of all of ours ought to be to do so without going back to the court. When you go to the court, you end up with decisions under which you have to live. If you can reach more flexible decisions on your own without going there, we are all better off. The futures awards that have yet to be used will be a big topic of this conference and are something that still need to be addressed. How can they be used? How will they be used? What's the future of the areas for which they were issued? Storage is probably the third issue. The tribes, the state are all looking at storage in this basin. How will it be used? How will it be built? How will it be paid for? What will its water right look like? Among those 3 things, if we can sit down in the next day and a half, in the next decade and a half, and work together, there are answers out there. We just have to believe that we can find them. Thank you very much.
Good morning. I find it very interesting to be standing up here, and I have to warn you that over the past 37 years, my interest has changed, and my presentation will not be that of what I went through in many courtrooms and in the master's hearings and even some of the general councils where I was drug over the coals over some of the things that we didn't do. As I say, I just want to warn you that my presentation today will be a little bit different. My father said growing up Indian was never difficult until he was sent to an Indian boarding school. Although my education was similar, things had changed, and I never found life too difficult until I was elected to the Shoshone Business Council. For today, the best place for me to start is the beginning of my 18 years in tribal politics and another 4 years as a deputy tribal water engineer. And as I recall, it started this way. On a snowy Thursday in November of 1980, a cold wind blew down the little Wind River the first night she came. But first, let me back up a few months. I had been appointed to the Shoshone Oil and Gas Commission, and we had spent most of August and September of 1980 investigating the trucking activities in the Sheldon Dome field. There we found that pipeline quality oil was being sold to a reclaiming company in the northern part of the state. And since the trucking of tribal oil had been done without a run ticket, it was turned over to our accountants, Ernst & Young in Denver, to determine the amount of financial loss. In October, the commission thought they hit a big one. At least, at that time, we thought it was the big one. The Steamboat oil field was comprised of 3 tribal leases with 3 different royalties. We found the operator, a major company, had been shipping oil down the pipeline but paying tribal royalties at the lowest lease royalty rate, and the company owed the tribes $1 million. We took a trip to Houston to pick up the check. While in Houston, we were told that it was an accounting error and it would not happen again, as they had fired the clerk responsible. Returning home, I learned that I had been nominated and shown general counsel to run for a seat on the business council. That was okay with me. Newly elected councilmen did not take a seat on the council until January, and the commission had learned from inside sources that there was a bigger fish to fry. A major oil company had been reporting production on tribal leases, but had failed to pay tribal royalty on 472,000 barrels of oil taken over a 6-year period. After back and forth talks, the company announced in a local newspaper that it was another accounting error. Now back to that Thursday in November, tribal council election night to be exact. The snow had stopped, polls had closed, and I was on my 3rd pot of coffee by midnight. A coyote yipped from across the meadow that runs along the east side of my house. I have heard coyotes before, but these yips and yowls were different, kind of lonely sounding, like the coyote had lost its last friend and was crying. Not long after, something scratched at my door. Edgy from too much coffee or the events of the day, I almost ran for my pistol. The scratch turned into a knock, 2 knocks, then 3. Creatures don't knock, I told myself and shouted. Who's there? No answer. 3 more distinct knocks. I grabbed the door handle, twisted, and yanked the door open. There, standing in the brightness of the new fallen snow, loomed a dark female figure, and aurora surrounded her. Kind of a glow, like soft, concentrated moonlight. She spoke. I just dropped by to let you know that you have been elected to the Shoshone Business Council. You have a big meeting coming up after the 1st of January. She took a large folder from under her coat and handed it to me. You'll need this, she added. All the tribal experts will be there for the meeting. She turned and was gone. Only the light scent of a mysterious perfume lingered in the air. Seated at the table, I opened the file folder titled The Big Horn Adjudication. It was filled with confidential tribal attorney memoranda. I started reading, and each day another folder would arrive. And like the first folder, with that light scent so awakening to my senses, I would read and read and read some more. By Christmas, not sugar plums, but questions were dancing in my head. Who has jurisdiction to decide the water claims along the Big Horn drainage and its tributaries, the federal government, the state government, or the tribal government. The federal government, and who the hell was this McCarran guy? Was he a mouthpiece for a group of people with a lot of pull and deep pockets? Or was he another guy like McLaughlin, who, posing as a friend of the Indian, had diminished the reservation by 1 million acres? It appeared this McCarran guy had made into law a way to take tribal water. And the amendment had become the state enabling tool to determine tribal water rights in California via Arizona. Following the same precedent, the state of Wyoming in 1977 had passed legislation to determine water rights in the Big Horn drainage, including the water rights of the Shoshone and Arapaho tribes. The morning of December 28th, I was called to a meeting at the Shoshone Oil and Gas Commission office. The topic was some photos the commission had come in possession of a month earlier. One of the commissioners had been contacted and offered $10,000 for the photos. Since the commission was not going to give up the photos short of a federal court order, the discussion turned to how far the person might go to get the photos. That evening after dinner, I was determined to understand the factual development for treaty-based water rights. The initial fact gathering for the treaty-based water rights had taken about 3 years. It took 3 years even though the parties stipulated to previously adjudicated rights in setting the boundaries and dates for the reservation. Treaty-based water rights requires the expertise of soil scientists, civil engineers, aerial photographers, interpreters, groundwater specialists, surveyors, persons knowledgeable about mineral, agricultural, commercial, and industrial development, wildlife experts, cultural experts, and historians. I asked myself, why all the experts, and who was paying these people? I learned that the first step in factual development is to determine the purpose of the reservation, and a treaty-based water right is the water necessary to fulfill the purposes of the reservation. The tribes asserted that water was needed to fulfill the following purposes on the reservation: fisheries, mineral, industrial, municipal, domestic, commercial, livestock, ranching, farming, wildlife, and aesthetics. January 2nd, 1981, I took the oath of office and was seated on the Shoshone Business Council. I could feel the tension in the room. The Oil and Gas Commission called for the termination of the attorney's contracts on grounds of conflict of interest. This did not set well with the older councilman, and later that night, she was back, and for the first time came into my house and sat down. She was visibly shaken, and when I tried to comfort her, she got up and fled into the night. To this day, I've never seen or heard from her again. Perhaps it was her way of saying I would have to go it alone. The big meeting finally happened 3 days before the proceeding started before the special master. And over the next year, I spent 2 to 3 days a week in Cheyenne. The special master's findings was sent to the district court for decision. That was appealed to the Wyoming Supreme Court, then appealed to the United States Supreme Court. The tribes were awarded 290,490 feet for historically irrigated lands and 209,372 acre-feet for future projects. The Supreme Court did not alter the trial court's holding that once quantified, the tribes could make use of their water as they deemed advisable, so long as the consumptive use is not increased. Consumptive use is the amount of water actually consumed after it is diverted. I think that this is key for future tribal generations to build on. As the nature of the reserved water rights is not what was used or what is currently used, but what might be used in the future. Thank you, and by the way, this is my opinion, and admittedly, the female was fiction and nothing more than a stretch of my imagination for all those wondering minds out there today. Thank you again, and I'm sure I'll see you in one of the breakout sessions. Thank you.
Good morning. It's a good day here in Wyoming. Any day outside of Washington, D.C. is a good day. And I'm very pleased to see the weather. I want to thank the tribes for their hospitality. One of the things I enjoy most about working with tribes is most meetings start with a prayer. And I love that. It's very centering. It helps everybody focus in the room, and so I want to thank you for the prayers. I want to thank Jason, who invited me here in the University of Wyoming Law School. Jason and I interacted on a project he was doing for Harvard, and I was working on the Colorado River, so it's nice to catch up with him again. I have been so fortunate, I have touched pieces of this adjudication and others, and I'm here to give you water rights settlements. So let me talk about a couple of things with respect to policy in the federal government. As you know, the federal government has an Indian trust responsibility. This current administration takes this policy very seriously. It is the policy of this administration that tribal self-sufficiency and sovereignty are crucial. The goal is to assist in providing successful and sustainable reservation economies. President Obama formed the Native American Indian Council, composed of members of his cabinet and Native American leaders across the country. Secretary Jewell is the chair. She's the Secretary of the Department of the Interior and my boss. They meet 3 or 4 times a year. Our secretary also has put forth a new order reaffirming the federal trust responsibility to federally recognize Indian tribes and individual Indian beneficiaries. This administration supports funding Indian water right settlements. Now, the lengthy and costly litigation that was going on in the late 70s and the 80s forced the government to say we need a concentrated way to deal with Indian water rights, and we'd like to promote settlement. So they formed in the late 80s the Secretary of Indian Water Rights. That office put out then criteria and procedures that allowed a way to walk through these settlements, allowed a process, although each settlement, as you'll hear, is very different and is its own beast. Not sure many of you know this, but the Wind River tribes in the state of Wyoming, and the federal government, actually tried to use that process. A federal team, a negotiating team was formed, and they tried to use that process after the first Supreme Court decision, United States Supreme Court decision. Unfortunately, those negotiations weren't successful. Now, while you were litigating, here's just some statistics of what was going on in other Indian areas. 30 settlements were finalized, 26 approved by Congress, came with congressional legislation. Currently now, we have 17 settlement teams and 21 implementation teams. Millions of acre-feet of water rights have been confirmed for tribes. $900 million has been approved for economic development for tribes. About 58% of the settlements provide for infrastructure, 81 provide for leasing or marketing water, and 42% provide for shortage sharing or prorating. I want to thank you all for teaching the rest of us in the country some lessons. First of all, you provided law. Law is what we use in other settlement negotiations to determine risks, to figure out which way to go. Do we agree with this settlement, or do we want to take our chances under the law? That was helpful. Is it faster to settle rather than litigate? Well, I was going to tell you probably yes, but we have a case, the Fort Belmont settlement discussions in Montana, that has been going on since 1989. Taoist parties spent over 20 years settling their adjudication. However, some settlements have, again, it depends on the different perspectives. Do you get more water or less water? Congratulations, tribes. Here, you got a lot of water. It was your water, and that was confirmed by the court. What we found in other settlements is have sought and gotten significant amounts of water, but in some cases they chose to give up some of that water for other pieces of the settlement, like some economic development funds, maybe some land, maybe in-stream flow rights, maybe groundwater. So again, it's a balance. Pat talked about the partnership aspect. When you're in court, you're foes. Somebody wins, somebody loses. There's no in between. In settlements, I think tribes have more opportunity to be directly involved, to be at the table, along with their attorneys and their engineers. And yes, in settlements, like I understand some of your special masters have done, sometimes the attorneys get thrown out. That happens in the settlements. Settlement battles can be just as combative. However, the final product has to go to Congress. This forces those foes who were fighting earlier to come together on a common front and push that settlement through Congress. In fact, a 2012 Senate report said that parties may not emerge from the process as friends, but a good process fosters respect and understanding. And I believe that's what Pat was saying. Process. We need to communicate. We need to look at how to move forward. Costs of settlement are probably less than litigation. I don't know. I read in an article, Judge Gary Hartman estimated that hundreds of millions of dollars were spent here for time, effort, and expense. Significant federal financing has allowed Indians and private parties to settle their differences elsewhere. However, you can get money authorized by Congress, and there is probably at this point about $1 billion in Indian water rights settlements out there that have been authorized. But in order to get the money, it has to be appropriated by Congress. So it's a continuing battle. So there again is the pluses and the minuses. Implementation of settlements, is it any different than implementation of adjudications? I don't think so. A lot of the settlements I've been involved in, we argue about what the settlement said, what the words say, what they meant, what's the history of the settlement. Just as many of you, as you move forward with the adjudication and the results of it, will have to figure out what those words say in a decree. So in closing, as you can see, I obviously have a bias towards settlement, but I just want to say each party has to choose its own path. There are pluses and minuses to both approaches. And it's who's to say which one is the best one. Thank you again for allowing me to speak.
All right. Many thanks to all three of our keynoters. As my colleague Deb alluded to, we chose these particular individuals not only because they're extremely competent and experienced, but because they represent both the federal, state, and tribal sovereigns with interests in this adjudication. Please join me again, I guess, in extending a round of applause to the group as a whole. Transition. At this point in the program, I'm going to gladly step off of the stage and turn things over to the special master in this adjudication who has served in this role since 1995, and that is Special Master Ramsey Kropp. So if I may ask Special Master Kropp to come up to the stage, it would be much appreciated. A brief introduction for Ramsey. Special Master Kropp is a shareholder with the firm Patrick, Miller, Kropp, and Noto, PC. It's a Colorado law firm that handles a good deal of water resources work. She obviously has served as special master in the Big Horn General Stream adjudication for going on 2 decades now. I believe assumed the position in 1995. That makes for 19 years, and if you divide that by the length of the adjudication, 37 years, that's roughly half of the proceeding has fallen within her realm of expertise. A huge accomplishment and a huge service to the public. Special Master Kropp, prior to assuming this Special Master position for the Big Horn adjudication, also served in various capacities on the Gila River adjudication and the Little Colorado River adjudication in Arizona. We'll be talking about those adjudications later in the program today. Ramsey has been an indispensable and incredibly generous member of the steering committee that put together this program. She's a CU Law School alum, our sister school to the south, and we're extremely grateful to have her with us today. So with that, I give you Special Master Ramsey Kropp.
See, he's helping me with the technology. This is a good thing, right? Good morning. It's a pleasure to see so many friends here and see a lot of new faces and to be so welcomed to the Wind River Indian that any federal agency claiming a federal reserve water right must participate in a state administrative process. So sovereignty of the United States government is waived for these special adjudications. In 1963, there was significant litigation in an interstate case between Arizona and California. In that case, the court upheld the standard of practicably irrigable acreage, which guides how water rights have been determined in water uses, and the state and the city of Riverton was concerned about getting bonding when there was uncertain how Declaratory Judgment Act, and shortly after that filed a complaint in 1977, after which there was a forum skirmish where the United States removed the case to federal court, and then, which is a process where you can take a case and put it into a different court. The federal judge said, no, I don't really want this case, and sent it back to the state court under the auspices of the McCarran. Moved the case to federal court, and all things have stopped now. While there's a motion out there to bring it back into state court, everything is stopped while they go through settlement discussions. But it was looking in a mirror some 30 years later to see that happen in Oklahoma. We were fortunate in this state to have an incredible initial special master, Tino Roncalio, who was a state senator. And he, again, was instrumental in this division of the cases and had the hearings for about a year on the Federal Reserve right claims for the tribes, and had the initial special master's report. And that report involved essentially, at the end of the day, again, as the other speakers have said, there were reserved rights granted for nearly half of the flow of the Wind River, Big Horn River system to the tribes, and the practicably irrigable acreage, or PIA standard, was used to quantify those rights. So this map is Division 3 again. What struck me about this map is that you can see the breadth of space that we always see in Wyoming, and the absence of rivers. So part of what drives these controversies is how dry it is most of the time. And I am grateful that it rained today too. That was a good sign. This is a map of Water Division 3 that shows how it becomes more complicated because it describes who owns the different lands. There's private land shown in dark green, state land in blue, BIA land in orange, BLM is yellow, Bureau of Rec, the Forest Service, and the National Park System own own land in the division. And so all of those different parties have claims to water rights. I talked a little earlier about the 3 prongs of the adjudication. The first one was the quantification of tribal rights. And again, that case went through a decision by the special master, and then went to the district court, went to the Wyoming Supreme Court, and then to the United States Supreme Court. United States Supreme Court, because they affirmed the Wyoming Supreme Court without an opinion. Justice Sandra Day O'Connor recused herself, and that was because she owned ranch property subject to a water adjudication in Arizona. And so the Wyoming Supreme Court decision was affirmed and is the controlling law of the case. The second prong of the case has to do with Walton rights. I think this becomes important because how many times the Wyoming Supreme Court returned to those rights. Walton rights are named that because of litigation in the state of Washington. The federal Ninth Circuit determined these rights based on litigation between the Colville Confederated Tribes and Mr. Walton. Mr. Walton was a non-Indian, but owned land that was formerly owned by an Indian allotee. And so the Allotment Act provided land to individual Indian owners, and the claim Mr. Walton had was that he should have the same priority date as the tribes for the water that he was using. In the Big Horn, we called them Walton rights because that's what they were called in Washington, and in other states they term them the same way because it's the same legal premise. In Big Horn 1, the Wyoming Supreme Court found that a reserved water right with an 1868 priority date for the PA that the Walton right claimant can show is irrigated by their Indian predecessor or put under irrigation within a reasonable time thereafter could make a claim. Allowed more claimants to be or the Wyoming Supreme Court said, no, we're not going to hear any interim appeals on this. You go figure all of them out before you come back to us. In Big Horn 5, the court determined that they weren't going to grant Walton right claims to super Walton claimants because of the accepted Walton claims that were determined by the district court and sent back, remanded unsuccessful Walton claims for determination as well. In other words, there were award of Walton right claims to nearly all the folks who made claims in that case. The third prong of the case involved administration, and this is an area where controversy was and still can be particularly bitter. It's difficult to overstate the importance of sovereign control of water resources, whether by the state or by the tribes, and this litigation kind of threads the needle, I guess. Big Horn 3's decision from the Wyoming Supreme Court, if I were to read it for the first time, if you haven't read it, you might start with Justice Golden's dissent. It was assigned to Justice Golden, who could not get an agreement between the justices, and there are 5 separate opinions. From that, 2 major issues come out. 2 major issues came from the majority. One is that the tribes can use their quantified amount of future project water solely for agricultural purposes, but can't change that water to in-stream use. The other decision I think that comes out of there is that the state engineer should administer water rights on the reservation and turn to the courts for enforcement authority. I think that some of the comments that the justices made in their separate opinions speak to the nature of the controversy. If I look at lessons learned in Wyoming, one of the things that was very good, I think, over the years and stood the test of time is that we have a short adjudication statute. It's very simple. It's about this long, and in contrast to other states where there's pages and pages and pages of statutory guidance. Because of that, parties in the court were able to shape adjudication proceedings so that they could function and move forward. The next thing I think that went the right way as a process in Wyoming was to go after and determine those federal reserved rights early in the process instead of pushing them to the end of the game. Once the federal reserved rights were acknowledged, the ability for the parties to work together and find settlements and move the process forward became much more possible, I think. In Wyoming, there was never any ambiguity in the state's role as there has been in other states. And so time and money and resources were not spent on determining what the role of the state engineer was. The state engineer's office was always a party in the case, remains a party in the case, and it was clear to all the parties and the court what that role was. And finally, I wanted to just mention settlements. In Wyoming, we don't have a general settlement that's gone through the federal government that provides money and outcomes that are good for all the parties. However, we have a lot of smaller settlements that have occurred. Non-Indian federal rights were settled. Appurtenancy claims were settled. Federal small stock watering claims were settled. Tribal groundwater claims were all settled. At that point, the court required monthly settlement conferences, particularly during the in-stream flow case, so that the parties would have more dialogue. We had a lot of different settlement activity throughout the Walton claims and the Phase 3 claims, and really required the parties to sit down and talk to each other. On September 5th, 2014, last Friday, Judge Robert Scar entered the final decree, and it was 1 page long, and its intent was to bring this case to closure and note that all the water rights in Division 3 have been quantified. On this occasion, Judge Gary Hartman stood up and reflected that when the people of Wyoming, whether they're tribe members, state residents, or any water users in Wyoming, when they get together and sit down for a cup of coffee, they're able to work out important matters between themselves. And the court's role in this has been to try to promote that kind of decision-making for this important water resource. One last note as I close. We've worked very hard in my office, and I want to shout out to Gayla Mead in the back there. You can raise your hand, Gayla. Gayla's been in this case kind of as the administrative assistant, office manager, and jack of all trades since 1986. She's been working very hard on a website. In the last several years, we have the entire record in a an electronic format that's going to be available to anybody in the public. And she has a demonstration that she can provide during this conference, and we'll try to set that up so people can see how that works. So she's glad that I'm volunteering her. Thank you for your time and attention this morning, and we'll have a short break, and then we'll have our next panel.
37 years and 15 minutes. I think it deserves a second round of applause. All right. Special master crop slides will be posted on the website for folks who want to reference them later. We also are fortunate in that Ramsey will be moderating a panel in just a moment consisting of individuals who were directly involved in each of the phases of the adjudication she referred to in her overview remarks. I'd like to ask the folks who are part of that panel, the retrospective panel, to meet me down here at the foot of the stage in just a moment. But for those of you who aren't, the vast majority, it's recess. Please come back, I believe at 9:30, and we'll embark on the retrospective panel. Thanks so much. Good job. Way to go. Not easy to do. Condense all of that in minutes.
Practicing last night, I kept coming out 25 minutes. Gotta go faster.
You were at 20. You're perfect. So you're literally almost directly on 9:15. I like Roncalio's an interesting character for me because I'm from Italian Wyoming ancestry. My family are miners in the town of Sunrise, a lot near the North Platte. I'll tell you the story sometime. But so Roncalio's interesting. But that last quote you lifted of his integrated some of Stegner's work. And Stegner's, I'm a huge Stegner fan. I was raised in majority culture, so kind of and Devoto a lot. But anyway, love it.
Good.
Yeah, very, very good.
I thought it was a good one. There's a great little article. That one,
They published it.
Dilemma.
Yeah, Getch's, it was in a book.
Recently, I said, "Oh, I just ran across this again. You should have it." And I was like, "Oh, perfect."
Let's meet with the panelists and make sure we have our technology needs met.
I would say, if anybody's PowerPointing that we want to.
You want to switch it?
Nancy is PowerPointing that. Maybe we switch the.
And I have two places.
The red just doesn't appear on the damn screen.
Neither do. Okay, so no pointer.
I'm so sorry.
That's what's okay.
What an anomaly. Why wouldn't it appear on a black screen? All right. Hey, let's go meet down at the laptop. How's that sound? I'm gonna get Jeff.
Talk about it, and then the other is pro-harvesting, and that's shoulders. I want to go first.
Okay, guys, there's 2 mics. So I'm going to ask a question and hand somebody a mic. So I'm going to do it. All right, if everybody can get settled back in your seats, we'll start with the next panel. Need to track down Special Master Terry Dolan. Come on up. Special Master that adjudicated several of the rights early in the adjudication. To my right is Susan Williams, who is an attorney in, from the Law Office of Susan Williams in New Mexico, correct? Sue has represented Native American tribes and Indians in legal and legislative matters all over the country. She's worked both in-house and as a contract counsel, and her experience was in the litigation during the early stages of the adjudication here in the Big Horn. And finally, Nancy McCann is the manager of the Big Horn River General Adjudication for the State Engineer's Office, and she really serves as the project manager for this case and the technical liaison to the court, and has done so in that capacity since 1988. There's a lot more I could say about each of these remarkable people, but I'm going to let them all speak for themselves. Our formula this morning is a little bit like a conversation, and what we would like to do is have a quick 10-minute introduction from each panelist, and then we'll have a few questions that we've talked about in advance that I'll be asking to the different panelists, and we'll talk among ourselves. I have several questions. I don't know if we'll get to all of them, but I think it should give you a flavor of the experiences in the adjudication. We have 2 microphones, and so we'll just be passing those around. Let me start with Terry Dolan, please.
Thank you, everybody. I hope I'm not too loud. I try not to speak as loud as some people like, but...
You need to hold it up pretty close.
Thank you, Ramsey. I appreciate it. And Professor Robeson, you've done a wonderful job putting this together. The one thing that's occurred to me this morning, I've been in Idaho for 20 years, and obviously it's been a rough 20 years because I'm the only one that's aged in this case, looking at them. Everybody else just looks like a kid, especially we have all our law students down here. They look like high schoolers. Well, anyway, Nancy, Ramsey rather, asked me to talk about the settlement process we had early on in the phase 3. And first of all, let me credit Judge Hartman, who appointed me special master in the case. He's the one who suggested we do it this way. We had monthly settlement conferences over at the Riverton Community College, and they were by court order. And the parties had to submit in advance a statement that they exchange between themselves of what the remaining issues are, but also what their suggestions were of how to solve those things. The meeting started off tense and formal, but we had the U.S., the state, tribes, Midvale Irrigation District, Riverton Valley Irrigation District, and LeClaire Irrigation Districts. And they were stiff and formal, but after a while things started settling down. But we had a huge list of the issues. First, the Walton issues: irrigation district claims, reservation groundwater, small stock and domestic wells, joint tribal and state field inspections, in-stream flows, all of this. I'm not blowing smoke, but this stuff just goes on and on and on. We had so many things to talk about, but the key to the whole thing was, and this was again a Judge Hartman suggestion, we had to come up with ground rules for these settlement conferences. First of all, the purpose was to settle, no posturing. Second, you had to work toward a solution, not talk about what the problems are. Third, we went to these separate breaks between the meetings where people could go out in the hall, and we found out later on that's where a lot of these issues were, if not partially settled, fully settled in some cases. We tried welcoming all technical people, because sometimes during these discussions a lot of questions come up, and who has the answer but the technical people? They were wonderful. But the last one, and this one I think surprised a lot of people, was when we said, let's try one without lawyers. Let's just have the parties there. And I thought it was wonderful. Not just because everybody developed that personal relationship, but because they were a lot less stiff. If you have a lawyer talking for you, it's one thing, but if you're talking yourself and you're meeting the person who's on the other side of the issue, it's a different dynamic. I think it worked because it developed that personal feeling between the parties. I felt closer to a lot of the parties, and I think it worked.
Thanks, Terry. The next person on my list who is going to give an overview is Jeff Fassett. Feel free to stand up.
I might. Good morning. Thanks. I appreciate Jennifer's comments pointing out where I grew up. That was completely unnecessary. I always introduce myself as I graduated from the University of Wyoming, which is true, and have been here ever since. I'm going to take the 10-minute rule on what was your role may be hard for me. I'm a little bit of a newcomer. I started in 1978, not 1977, on this case. So I do want to just sort of quickly review sort of my views of the role before we get into other sort of substantive things, because I've got a very long history and was so much a part of many pieces of this, whether I wanted to be or not, in many respects, that I wanted to take an extra few minutes to really get through some of this. My role really started as a technical person. I was glad to see my former colleague, Ron Bilstein here. He and I were both in our 20s when this case started, and I was involved as a consultant to the state of Wyoming. We were actually hired to do water rights engineering, hydrology, groundwater work. We developed a very big computer model of the entire Wind River Basin, and all of that was done while I was a consultant for the state, working for the Attorney General's office and the outside counsel at that time. In that role, we went through all of the proceedings, like I said, starting in 1978. After the procedural hurdles were through, we of course launched into the Big Horn 1 set of trials before Special Master Ron Collio. And we could have a whole conference on those of us that were there, as John Washicki and others have talked about, just talking about the stories of what happens during 45 weeks of trial amongst the parties and the process itself. But I was a part of all that, had my own turn in the barrel on testimony and cross-examination for several weeks, among many, many others who went through that very arduous sort of process. While awaiting the decision after the trial was done in Big Horn 1, we were waiting for the initial Special Master's report from Special Master Ron Collio. I was also actively involved in Phase 2, the settlement process, or what turned into a very lengthy and productive settlement process, resulting in the stipulated interlocutory consent decree between the state and the federal government dealing with all non-tribal federal reserved water rights. For the national parks, national forest, little corner of Yellowstone, public water reserves, stock driveways, every imaginable federal reservation of land and issue, some of which were resolved with state water rights, but the reserved water right aspects of those federal reservations were resolved. And again, I was the technical person who sat with most of the lawyers, again from the state side, working through some of the very early theories that were being presented, particularly interesting theories about hydrology and stream flow activities within the national forests that were it's hard to think in 2014 how new those concepts were in the early 1980, dealing with theories of David Roskin and the policies and development of activities about how you quantify water to meet the purposes of a federal national forest. And it was actively involved with that process, and of course that was settled. Nancy McCann and Harry Burden and working with the federal agency to operate the massive decree that came out of those settlement negotiations got cranked into the final decree and processes that were approved just last week. Then for unknown reason, I left consulting and came to work for the state. State engineer George Christopoulos hired me as his deputy, so I went from being a consultant, an expert to the Attorney General's office, to, in some respects, becoming the figurehead and the client as being in the state engineer's office. I was then later appointed as the Wyoming State Engineer in 1987, stayed there through 2000, and as you followed Ramsey's history of the cases, I had I guess it's pleasure of, of being the person when so much of those very difficult issues were there. I became the figurehead. I did not bring my slides, but when you've been found are in Wyoming and understand the history of the Casper Star-Tribune, to wake up and read the morning paper and see a cartoon of yourself. A very well respected and famous cartoonist on the staff of the Casper Star-Tribune back in the 1980s, and I was unfortunately a frequent subject matter of the paper, generally being faithful towards the views that were being expressed by the state in the litigation at that time. I have a wonderful plaque in my office of those cartoons just to let you know that I've maintained my sense of humor, even though living through that was not the easiest part of your day. But we were there, I was there, I went through the Big Horn 1 case, as I said, we settled the Big Horn, or the Phase 2 case, and then all the decisions, or many of the decisions on Walton that Ramsey admirably summarized, was during the time when I was a state engineer, dealing with these issues, dealing with the settlement, with the litigation, with implementation, everything going on at the same time. And as several people have commented, we tried a number of settlement forums, activities, shapes of the table, how many people, every imaginable approach to try to break the chain of litigation that seemed so difficult to break during the years, during Big Horn 1 and some of the subsequent years thereafter. I was, of course, and we can maybe talk later, the subject and was lucky enough to have the chair that Pat Terrell's in now when the Big Horn 3 situation came around as well. And the painstaking activities, proceedings, difficult decisions, even additional stress among the parties that developed at that time, which was all during also one of the driest years of record in the Wind River Basin, which sort of only added to the tension that was being worked. I then finally woke up and moved on to the office in 2000. I'm very pleased to come back, although this is both an interesting and an odd experience because I have not been directly in the game. Of course, since that time, I passed the baton to Pat. He now is working through all the various decisions and activities, and I've had the fortune to sort of remain in Wyoming, remain in the water rights world, and continue to monitor all of these activities. And so it has been a very interesting ride. It was both a fortune and misfortune to perhaps be the figurehead for the state and a lot of the state's position and activities that became so litigious. But as several people have commented, we had some great successes. And quite honestly, one of the successes was to not let some very difficult things become personal. We still are friends. John Schumacher came to my retirement party. We remained in contact. We remained professional through some very, very difficult issues and times. So thank you, Ramsey, for this opening opportunity, and I'm glad to hear from the comments and our further questions. Thanks.
Next, I'd like to ask Nancy McCann. I'm going in alphabetical order in case anyone wonders.
Good morning, everyone. I am Nancy McCann. Sometimes I don't like to admit it because along with that goes the stigma that you're associated with the Big Horn case. But I can tell you that working on the Big Horn case has been the most wonderful opportunity that a person could ever have, even though there has been lots of trials and tribulations, as one of the former speakers had mentioned. What I wanted to tell you is that I really did enjoy the storytelling of John Washakie as he was telling that about the Big Horn case. The way I look at it, and I'm in line with what John said, is that I thought of this whole journey on the Big Horn case as a journey with an extended family. We had the Tribal Water Engineer's Office, we had internal staff, we had parties to the case, water appropriators that had concerns, we had judges, special masters, and experts to the case. But all of those folks were actually an extended family on this wonderful journey with the Big Horn case. And I truly appreciate all those folks that participated in it, because we actually have something that's real, something that can be implemented. It provides certainty for the water appropriators, for the tribes, for everyone involved in the case, and I think that's important. But I do want to say one thing. Jeff? Express myself to Jeff about the opportunity and the thanks that I give to him for giving me the opportunity to work on the Big Horn case. I also wanted to express an opportunity to Debbie Hallberg, who has been on this long journey with me from the beginning. She had worked in the Attorney General's office on the Big Horn case, and she's still with me on the Big Horn case now at the close, and it's been very important. And I would be remiss in also saying that the field staff, Lauren Smith, Craig Cooper, Randy Maxwell, those folks have been extremely critical to helping move this project forward. They've been wonderful. And the other folks, I never say it, and I'm going to say it now, Ramsey, is that you and Gayla Mead have been very critical and have become friends, and I really do appreciate all the work that you have done to help keep me focused too. And finally, I'd also like to say thanks to Pat Terrell, because there's still a lot of rights to do, and so So I appreciate that, Pat, and I hope to continue until I finally get to turn in those retirement papers. One thing I wanted to point out is up on the screen, and this was also one of Ramsey's slides. This is the entire state, and you see the reservation on there. There were a lot of appropriators besides the tribes that received water rights. And I wanted to point out that lots of different irrigators were also out there. Let me point out Midvale Irrigation, Cody Canal Irrigation District, the Hart Mountain Irrigation District, Sidon Canal, Big Horn Irrigation District, Elk Level, Farmers Canal. We had large reservoirs out there, Anchor Dam, Pilot Butte, Bull Lake. For Bureau of Indian Affairs projects, I worked closely with Ray Nation and those folks out there at the Bureau of Indian Affairs for Aragon Canal, Left Hand, Wind River A. A lot of you already know all those names, but it's important to know and understand that this Big Horn case affected a lot of individuals, and the result is we now have decrees. And I did bring extra copies of the decrees that we just received on September 5th, and I will have those available later, because if you want to see what one looks like when you close the case out, we have it here so that you can take a look. I quickly wanted to just, if I have time, throw up a couple of pictures here. That is Water Division 3 as you would normally know it, with the reservation on superimposed on that. But when Ramsey had her slide up, this is also a slide of Water Division 3, and the reason this slide is important is because Yellowstone Park was also a part of the case under Phase 2. Now this slide, I don't know if you can see it all that well, but I wanted to point out that this is the reservation boundary. This is different than the boundary that the water rights for the tribes were quantified by. This is a picture of the state rights that existed prior to the tribes' rights being awarded. You'll notice that this is a picture of the tribes' rights after they were awarded. And these are the Walton rights that were awarded. Now, this happens to be a quad map of one quad topographic map that shows all those rights that are out there. Now, if I didn't mention it, this is a tool called GIS, Geographic Information Systems. For those of you who are not going to become lawyers when you're going to school, I suggest you get into GIS, because this technology is one thing that can help solve a lot of problems when you actually get to see the water rights on a map, and I mean all the water rights together. This particular map is the water rights superimposed on an aerial photo. Back in the day, we didn't have that technology, but we do now. And then this is, again, more of the same rights, more of the same. And so I wanted to make sure that you knew, because for educational purposes, you need to learn about GIS and the use of technology.
Thank you, Nancy. And even if you're going to law school, I would suggest you learn how to use GIS and talk.
From several speakers, a lot of us began involvement in this case when we were much younger. It began in just out of Washington, D.C., and my first job was to prepare the joint appendix for the Big Horn 1 decision. The court needed, in particular, with respect to Big Horn 1. So I came out from D.C. to Cheyenne, started on a Monday, and had to go through all the boxes of records. I mean, Nancy said you can get a copy of the decree so you can see what it looks like to finish the case. That's a 2-page document. The volume of records in this case would cover this stage, probably at least this high, and I may be underestimating, of what got generated in records, and that's not to include the separate records that each party might have had from their technical experts and their legal groups. And I was putting that record together, and it was getting to be Thursday, and I still had boxes of documents to go through to find the ones that the parties had identified, and was telling the people with the Supreme Court that, you know, if I didn't finish on Friday, that I would come back. No, I won't. I have to get this done. And they said, nope, Cheyenne Frontier Days is coming. You won't find a room anywhere. You're either getting it done this week or you're not coming for a couple of weeks. And so we stayed late at night to get that done. And then I was involved some in the briefing on Big Horn 1. And then I took a hiatus from this case and moved to Arizona to work, and did some work on related issues with the Arizona v. California litigation on behalf of the tribes down in Arizona. And in 1991, I was asked to come back up and work as an in-house attorney for the Shoshone tribe. And again, got back involved in this litigation. And at that time, Judge Hartman had ruled on the in-stream flow case, and that was going up to the Wyoming Supreme Court in what became Big Horn 3. And then I proceeded to work for the tribes through the early 2000s. So I was involved in Big Horn 3, 4, 5, and 6. And in that time also, we dealt with Phase 3 and the state rights. And many people don't recognize that not only do the tribes have reserved water rights, they also have state water rights, because they have water rights that didn't meet the elements of a reserved water right, but still met the elements for a state water right. So they've got multiple rights in this case. We dealt with overlapping permits. We dealt with groundwater issues. We dealt with pertinency issues, which is how does the tribal water right flow if it's based upon an individual's land and they're selling their land. And we resolved some of those issues that were there. And we had actually a water settlement in the early 90s in the drought year, where we had a one-year agreement where the tribes wouldn't enforce their water rights. The tribal members had their water to use, and in exchange for that, to protect non-Indians during that dry year, the tribes received a payment from the state. And so they were able to, in a drought year, figure out how to make it work for people on the ground. And so I was involved in a whole lot of aspects of that, and I was involved from the aspect of being physically on the reservation, which is different than representing the tribes if you're doing it from DC or Denver or some other location. The states actually had an out-of-state attorney that worked for them for a number of years, because you start seeing the practical aspects of what it is that you're litigating for. One of the things we asked to talk about is, how did your perspective change? And coming out of law school, first coming up here, it was protecting tribal sovereignty, quantifying the tribe's rights, protecting the water for their future, and doing that on a legal theory basis. Okay, this is the legal analysis, this is the law, and we're going to push that to the extreme. And over time, my perspective changed, not to protect those things any less for the tribe, but fight those battles in a way that ended up with something that would improve for tribal members on the ground. For example, if you're fighting on administration and the tribe's right to administer, are you fighting harder to preserve that right within the BIA districts, or how hard did the tribes want to be involved within something like Midvale? They wanted to make sure Midvale wasn't taking care of their water and it was administered so that the tribe's water was in priority, but were they going to be really that concerned with individual water users with their state rights? And so you looked at those things on the ground. How was it going to affect the tribe's water? And you had to figure out how the BIA was going to handle those rights, how the tribe was going to handle those rights. And if that's one message I have, is as you're doing these cases, whether you're doing them in settlement or you're doing them in litigation as a lawyer, is understand from your client, look at, with the technical people, what is the practical effect? Because there's sometimes you may fight a battle and the only thing that benefits from that is the attorneys got paid and you got a nice court ruling, but it didn't change how a tribal member could put water on their land and grow a crop or use it for something for economic gain, or use for the tribe itself to use it for a cultural purpose or a natural resource purpose. Look at that practical aspect of what's there. The same legal issues are involved, but how you argue those issues and the outcomes you look for change with respect to that. And for me, one of the biggest kind of substantive issues in the case, which turned out legally not to have a lot of precedent to it, but changed the dynamics of how people litigated this case, was the Big Horn 3 decision. As was stated by Ramsey, you had 5 separate opinions from the Wyoming Supreme Court. And this was the case that dealt with the right of the tribes to use in-stream flow, as well as the role of the state in administration on the reservation. I have a little different take than Ramsey, as you'll find all of us have a little different take of what the decisions mean. My interpretation of the decision was that the tribes couldn't do what they did, but if they did it slightly different, they might have had a different outcome before the court, because you had the 5 different justices disagreeing on what the result was, as well as disagreeing as how you would get to that result. So in-stream flow isn't necessarily off the table, but how you go about doing that, the tribes didn't do it in the right way to do that. It also provided only marginal guidance, I think, from what Big Horn 1 said with respect to the state engineer's role. But the big thing that came out of that case was it made everybody realize that the court couldn't solve a lot of the problems dealing with the tribes' water rights and the state water rights within the basin. You had 5 different decisions. They all had their own different theory, and I think it's worth pointing out as you look at subsequent decisions in this case or in other cases, Big Horn 3 is rarely cited. It has something for everybody and nothing for anyone. But its lesson is that sometimes you have to go to litigation. I mean, in Big Horn 1, we got the tribes' rights quantified. We ended up having to get the Walton rights decisions decided before the court. But there's a lot of things that either the court can't decide or they'll screw it up. Because I think that the Big Horn 3 decision, as opposed to resolving things, I mean, Big Horn 1 resolved, got the tribes' rights quantified. Big Horn 3 created more questions and potentially more litigation. And so the lesson from that is to, get answers from the court when you need to, but don't assume that the court's actually going to make it better, whether you win or lose from a given decision.
Thank you, John. Our last panelist to give perspective is Susan Williams.
Thank you, Ramsey, and good morning, everybody. I feel like I'm part of the old Coots Club here now. Seeing everybody after all these years. John Washik, you had to correct me. I thought it was only 20 years ago, and he goes, no, it was about 25. I got involved in this case when our law firm, John and I, our law firm back east that we were working for, the Freed, Frank, Harris, Shriver, and Jacobson firm, was retained by the Shoshone tribe in the late, early 1980s. And boy, they were doing a lot. They had a lot going on, as John Washik described to you. You know, they had all these oil and gas investigations that were really quite stressful to see what, people really could do out of greed. And it was also a very important time to really understand what the reserved water right was, because at that time, before this case, there wasn't a federal sort of supreme law on how you quantify an Indian water right. And as was explained, this case was based on a computation of the tribe's senior federal reserve water right based on the practically irrigable acreage. And there were several other uses that the tribe had laid claim for. And some of them were subsumed, a bit recognized, but some of the decisions by the tribe as far as their economic future based on use of this PIA water were still very much up in the air, so to speak. Our firm got involved as this case was moving from the district court to the Wyoming Supreme Court. And I can remember I'll never forget, like John, having to go deal with the joint appendix. My then co-associate at that firm, Kevin Gover, and I flew down to prepare to start briefing in the Wyoming Supreme Court. We went down to Boulder, Colorado, and we spent a week there, a similar sort of thing, day and night, pouring through all of the record of the case, which, as I am told, it was one of the largest, if not the largest record that ever went to the U.S. Supreme Court. It was, like John said, we could probably drown in paperwork if it were all dumped on us right now. So it went to the Wyoming Supreme Court, and as you all know, the Wyoming Supreme Court has laid out the law of the case here, quantified the practically irrigable acreage both for present uses and future uses, and said all the other claims could be, for example, the domestic claim could be subsumed under the PIA claim, because the PIA claim maximizes the water right. It's a lot of water for irrigation purposes, and that's what went on here. The role of the technical people, there were so many technical reports, it was unreal. You know, we're just lawyers, and but the technical work to quantify PIA it's massive. It's beyond what people really understand. There's so much detailed technology that has to go on, and analyses and economic analyses and so forth and so forth. But what was clear is that the United States, in its role as the trustee for the Indian tribes in this case, and I think the Wind River tribes very much appreciated the United States very actively asserting the tribes' rights and protecting them in this case. The tribes' reserved water right was a very, very, how should I say it? A lot of people didn't understand it. It took a long time, I think, for both the tribe and us lawyers who were new to the case to understand, okay, what exactly are the nuances? Because there were many nuances in the technology and the legal claims and theories. There were theories all over the place about how to quantify the tribe's reserved water right, ranging from there is no reserved water right because the reservation was disestablished to, well, if they do get a right, they got to really, really prove on the economic analysis that these things would happen and the projects would happen and so forth. So as it was going to the Wyoming Supreme Court, what was very, very, and the result of the Wyoming Supreme Court decision in 1988 was to affirm the bulk of the tribes and the United States claims on behalf of the tribes. In addition to the claims for trust lands that the United States undertook to represent and had some very, very, very good technical people who the judges and the special master found persuasive, Woldesine Mesgina from the Natural Resources Consulting Engineers. Over and over again, as I was reading in the dead of night about, what the courts thought of his technical work, over and over again, they would say they just find him more compelling. Over and over and over again on a number of issues. Same with David Dornbush, who did the economic analysis. His analysis was just better. And that was the work of the United States, and that was a lot of money that was devoted to making those claims in that fashion. So in 1988, the decision comes out, and the question was on everybody's part, do we want to appeal this? And the state, of course, made a decision, I think, fairly early on that the state wanted to appeal this decision of the Wyoming Supreme Court in 1988. But the tribes had a more difficult discussion in the General Council because we said, you got a lot here. And the Supreme Court, is like John Schumacher was saying, when you go to courts, boy, you run a risk of losing things. And so we recommended initially that the tribe not appeal the case, but if the state were going to appeal, we thought it would make us look weak if we didn't appeal. So we did a cross appeal to the United States Supreme Court. And the only issue that was certified for review in the Supreme Court was the issue of whether the practically irrigable acreage standard was the appropriate standard in this case. So we briefed, and it was on its way to the United States Supreme Court. And the United States, when it did accept the case, then we immediately started our rounds of briefing and thoughts about how to proceed, and also understanding what other parties might have to say, because the states all had a huge interest in this. There were quite a few briefs filed by the various states on their theories of how to quantify the water right, other than through PIA, because PIA, the amount of PIA award that the tribes got was pretty significant. In addition to the trust lands, the tribe filed claims for Indian-owned fee lands within the reservation, and those were given a Federal Reserve water right as well. The United States didn't claim that because they said they didn't have a trust responsibility, but nonetheless, this is a good reason for tribes to be involved in these cases. If the tribes hadn't submitted those claims would not have been confirmed and adjudicated in the courts. So it was really very, very, a lot of time, as John said, sitting in meetings with people, Indian lawyers throughout the country had their views, and professors on how to shape the case, how to argue it, what to say. And so we were in the process of going through that and informing people and finding out if there were other Indian tribes that wanted to submit amicus briefs. And it was just a flurry of paper and activity and phone calls. And in the course of that, I got a phone call one day from a law school colleague of mine who was a lawyer for the Senate Energy and Natural Resources Committee. And he said, I wanted to let you know that the Wyoming congressional delegation has obtained a rider on the Southern Ute Settlement Act that would declare that there is no Federal Reserve water right here at Wind River. So we then had to deal with that. And we lobbied the congressional delegation to get that off. Just take the rider off, let the Southern Ute settlement go forward. We didn't have any problems with that, but they wouldn't do it. So our strategy had to be to try to kill the bill. And we proceeded to try to do that because we couldn't have that rider. I mean, it would take our case out of the Supreme Court. There's no Federal Reserve water right. That's what Congress says. So we said, okay, let's make an attack on the whole, if they're not going to untangle them, then we're going to have to attack the Southern Ute bill until that rider's off. Well, that didn't go over too popular with the Southern Ute tribe. I'll never forget the day their lawyer, Tom Ships, called me, and he screamed so loud and so long, I really couldn't pick up much of a word, and so when he finally petered out, and I said, well, Tom, it's not that we're opposed to anything that you got in there in the Southern Ute bill. It's just that rider that you guys got on the bill is what's taking you down, and if you can help us get that rider off, then, we can do it. We'll support you. And eventually that happened. So we were free to go to the Supreme Court and argue whether or not there is a reserve water right for the Wind River tribes. During this period, we were so active in litigation, the idea of a settlement really wasn't discussed or focused upon a whole lot. There was just so much work to do and to preserve the water right that we didn't start thinking about, well, should we put a halt to this? And we tried. We told the congressional delegation, we'll try to work out a settlement, but there just wasn't the gel at the time. The other parties didn't really want to sit down and negotiate, so that's how we ended up getting a decree in Big Horn 1. Right after Big Horn 1 happened, there was the summer after Big Horn 1 happened, as Jeff was saying, this was a drought period, and this is why there was a lot of fear on the part of the non-Indians who now had a junior water right, meaning the tribes would get all the water during drought if they need it. And so there was a lot of tension that summer over the BIA's plans to go ahead and enforce the senior Federal Reserve water right of the tribes that summer, vis-a-vis the non-Indian farmers in these BIA irrigation projects. And when that word went out, oh my gosh, I kid you not, there was rumors that we were going to have to get flak jackets for our tribal water engineer's office, and I mean, it was serious. The tensions were horrible. To give you an example, just a little anecdotal story. One time my then partner, Kevin Gover, was up here working in the tribal court on I think it was a tax case. Yeah, it was a tax case. And so he and one of the non-Indian lawyers involved in that case were at the Holiday Inn in Riverton, and they were sitting in the bar and just minding their own business, and there were, frankly, a bunch of non-tribal members in there. And they started getting mad because they saw, my partner has long hair, or he did, he doesn't now. He looks funny, but so they were sitting there, and all of a sudden, one of those guys walked over across the bar and just knocked out the non-Indian lawyer and said, "Those damn Indian lawyers!" And my partner just got up and left, and he said, "I feel sad for that guy. Did he ever say that he wasn't an Indian lawyer? He was representing the non-Indians. You got the wrong guy." So, with all of that, as John Schumacher said, we worked out a one-year deal. Peter Maxfield represented the state in that, and I don't know where he is these days, but we worked out a deal just to try to maintain peace in the valley for that summer. And so that's how we ended up agreeing that we would work with and this is where the technical people started first coming in and really, really helping with the case, because the job of the technical people was to figure out how to get the water shared among all of the users in what was going to be a drought year. And that was going to require a lot of ingenuity, creativity, and new ground, precedent setting. So we entered into that agreement and thought this was a good idea to, just, move forward for a year. It was only a one-year agreement. So we did enter into that. Tribes got a very significant monetary payment and acknowledgement from the state. And turns out, it's funny how these stories go, that summer, it rained and rained and rained and rained, and we had flood conditions. So there, but you never know. It had been a drought, it would have been a good deal for the state, but since there wasn't, we never, the pressure on these guys kind of lessened a little bit after that. So then the question became for the tribes, now that we have this decision, how are we going to use it in a positive way and create economic development and put water, especially the future water, to its highest and best use? And so we began that thought process as we were trying to begin a negotiation with the state and the non-Indian parties, the irrigation districts, on how to move forward given that decision. And we had some ideas on, opening up future projects and getting funding for them and things of that nature. But, a combination of things, in my view, and looking back at it, really made it very difficult to come to some agreement about what Bighorn 1 meant and, to kind of go into a global settlement of how to implement it with all the parties. And I think, as I look back on it today, what really prevented people from sitting down? I think, for one thing, there's, as you know, and all of you who live here know, there was a long history of tensions between the tribes and the non-Indian irrigators, years and years of it. You hear stories of kids in school, Indian kids being beat up by gangs of non-Indians, and it just was bad. There was a lot of stereotyping of people, especially the tribal people. And so there was this long history of, hatred and animosity. And so I think that tension was a backdrop that I probably underestimated at the time. It really did divide the parties, and how to address things like that is not an easy thing. It takes time and all of that. The other thing that I learned from that experience is that you really have to appreciate the role of personalities, both on the state side and the tribal side. And I've seen this also in my subsequent Indian water cases, is that sometimes the kink in the whole process is either a political person or a lawyer representing one of the parties who just don't know how to say yes, don't know how to settle, don't know how to do constructive things and find things that you can get in settlement that you can't get through litigation, practical solutions, things of that nature. But I think that was very important to really understand. And then there's the art of negotiation. In those days, lawyers were taught to litigate, not negotiate, and particularly the U.S. Justice Department saw its role as representing the tribes as trustee, and therefore they felt like they were on this litigation path. And were open to the tribes coming up with settlement ideas, but I think the U.S. was content that it had done a very good job of protecting the tribe's senior federal water rights and getting them quantified. The other thing that I learned in looking back is the role of the United States. I think that none of us really understood, whether the United States would support us in negotiations, and that really they were very, tepid about it. They said, "Look, if you guys want to negotiate, that's good. We'll support you, but the tribes need to take the lead on that." And so we understood that, and again kept thinking and talking about how we could use the water in a good way moving forward into the future. The final thing I think I learned from that era is that you always have to keep your pulse on the political process, Indian tribes, in these settlements, because you never know. A lot of these congressional riders and add-ons and so forth can be done in the dead of the night. And so you got to have contacts who are up there in the know. So as in our case, someone will call and just say, here's your fair chance to fight that rider, instead of having the rider enacted and then we find out later. So I think that's very important, to keep your pulse on the political players in all of this. Well, so we never did come up with a comprehensive settlement to Big Horn 1, so we moved forward with our analyses of how in the world, and this is all still while we're doing the Walton claims, but we moved forward with our analysis on, what's the best and highest use of the Wind River Tribe's reserve water right. We hired an economist who did an analysis for us about, given the economy and, what she could project for the future, that she would, she recommended that the tribes devote their future water right to in-stream flows and rebuild the fisheries and make a fish-based economy here, fishing, tourist economy, and that was the highest and best use of the in-stream, or of the water right. So the tribes then made the decision that, given some of the earlier decrees and other case law, that there's no problem with the tribes devoting their Federal Reserve water right based on PIA, devoting some of it or all of it if it wanted to in-stream flows rather than farming it. And so the tribe made a decision to go ahead and do an in-stream flow permit for the tribe. So we did that, and under the Big Horn 1 decree, under the administration section, you're supposed to go to this, it says that to enforce the decree, you first have to go to the state engineer. So we did that. And Jeff decided that we didn't have the right to do that, so he did not authorize, under the Big Horn 1 decree, the tribe's dedication of some of their future water right to in-stream flow. Now, what's very important here is that, had tensions not been so bad, maybe we could have talked to each other better. I know we put outreach out there to the non-Indian irrigators about what we were doing, but I don't believe there was detailed, sincere discussions about what we were doing and how the tribes could benefit and how the non-Indians would not be harmed. We had USGS study that said this in-stream flow dedication will not affect the farmers' use of water, period. USGS. I mean, they're, pretty darn good technical people. But that fell on deaf ears. So we litigated. We had to litigate. We went into court to the state court and tried to get the enforcement of our reserve water right. And Judge Hartman said, yes, we can do that. But by the way, since the state engineer wouldn't enforce your water right, I'm going to switch the role of the administrator from the state engineer to the tribes. And boy, that was a surprise to us. We didn't really push for that. But the good news was from that is that the federal government put a lot of money behind getting the tribal water engineer's office set up in a really, really good office, and good people, good staff. And I just think it's one of the model programs for enforcing an Indian water right. And we have a water code that we did in order to establish the process for the state tribal water engineer's office to issue permits and enforce them. Enforcing, that is, the Federal Reserve water right and the permitted uses for it in locations. So I guess the final thing I will note is that, and you can see it from up here, there's some camaraderie up here. I mean, we all went through this. It was a hard time. And today, there's more practical solutions going on the ground, as John Schumacher has said, and, our people work together a lot better than they ever did. And, I remember those early days when the State Water Engineer's Office, Gary Cooper, and our people would go out on the ditches, and it was different. It was really different, and it had never been done before. And now it was being done. And that's good. Everybody benefits from that kind of joint governmental cooperation. So that was good to see. But the camaraderie that you get is something else that I think we'll all carry with us for the rest of our lives. And I want to close by saying that I think I'm one of the only women, other than Schumacher's wife and Jim Clear's wife, that have slept with him. Okay, before you gasp and faint, one of the things that we did after Big Horn 1 was we went on a mountain trip. The Shoshone tribe has their beautiful mountains divided up into outfitting areas. So we took an outfitting trip up there just to, have a little good time's sake. So Jim Clear went up with us, and John Schumacher, I went up, and several other people went up. to the mountains. And Jim Clear was a very tall man. You should have seen him on a horse. His feet were practically dragging. I don't think they could find a big enough horse for him. But we all went up into the mountains, and it was just, really, really, we were all happy. We felt like, geez, something good happened to these tribes, and we're just going to go enjoy their beautiful mountains and their fish. And so we all went up and trucked up there. We got up there, set up the base camp, and all of a sudden it was towards the evening, and all of a sudden this huge cloud cover started coming in, and we were like, what do we do now? And, all we had was tents and stuff like that. So, boy, the storm got worse. Make a long story short, we all were so scared that we got into the biggest tent, and we all lay next to each other like sardines, praying that we wouldn't get struck by lightning. And there were bolts hitting the campground and everything. So, yeah, I can say that's something I might put on my resume. Thank you.
Thank you. Okay, so as you can tell from these intro comments, we're trying to pull back the curtain a little on what different parties were thinking at the time when this initial litigation was going on, and what the feelings were between different communities of water users in this area. We have a few questions that we're going to discuss now in sort of more of a roundtable discussion, and we'll start out with kind of going back more to the earlier part of the case, and I'll start with asking Jeff Fassett if he can give us a little of the context and the tone and the factual setting that really made the state of Wyoming go to the legislature to begin the adjudication statute and to file that complaint.
You sure you don't want Sue and I to debate Big Horn 3 again?
Well, we may get there.
Okay,
we need to keep everyone's attention.
I think, as Ramsey indicated, the backdrop, and there's interesting letters and historical documents going back to sort of the beginning of the allegations of the assertion of these winter rights, which had, of course, long been established by law, as others have summarized in 1908. But it really sort of boiled to a top in 1976, leading into 77, where there was sort of allegations that when the city of Riverton was pursuing the development of some new groundwater wells, that the groundwater was owned by the tribes, that the underground water was theirs, and that the city needed to get some approvals from the tribal governments and could not simply get a groundwater permit under state law and pursue that project. I think Ramsey and others have talked about there. There were some other sort of interesting factual situations of tribal members and non-tribal members sharing ditches, and just the loose language. This was before any rights were established, but just the idea of asserting that a winter rights was out there, that I have a senior right. That really led to the discussion about, well, what are those rights? It's hard in 2014 to think about that discussion going on 37 years ago. We know so much more about this entire body of law that was much more uncertain back then. And I think that did lead to the internal discussions among the state's attorneys, a whole raft of, when you look at the original adjudication and the original complaint, there's an interesting listing of the attorneys that were involved in consulting with the governor and the attorney general back at that time, that sort of led to the initiation of the authorizing statute and the filing of the complaint just a couple of days later in the Whirlwind Court. But it really was there's some really interesting language in a letter from the tribes to the city of Riverton that was really a very broad assertion of really all of the water, above, beneath, flowing through, and bordering the reservation. And when the non-tribal water users read that kind of language, it immediately got the attention of a lot of people. It just sort of created such uncertainty. And I think it was that uncertainty that really probably led to the idea of trying to quantify. And of course, the only way to really legitimately quantify all the rights, federal, tribal, and otherwise, was to pursue under general adjudication process. And that's why that statute was triggered. I don't think it'll ever be done in another water division, but the uncertainty of the tribal reserved water rights, obviously the seniority, the date of reservation of being ahead of any other water user in the state of Wyoming, that needed to be resolved one way or the other. And I think that's sort of my quick view of the history.
Thank you. So the state goes ahead and files this complaint and begins the process. So maybe Sue, can you speak to us a little bit? I know you came on a little later in the game, but you can tell us a little bit about tribes' reactions to that initial complaint and how they set policy to try to go forward.
Yeah, I came in later, so I've heard it secondhand, and you got a little taste of it this morning when John Washakie told you about how he got involved in the case, and it was just this is constant reading, trying to figure out what in the world was going on, and there was just a lot of stuff in the record, so to understand what was going on and who was doing what, you had to look at all the technical stuff as well. So, but I think. In general, over time, what I've understood is that the tribes were happy that the United States, really put an all-out effort and really assembled a very good team of both lawyers and technical people. I think a real dream team of both lawyers and technical people on their end. And I believe the tribes, and I certainly, as a tribal lawyer, appreciated their help. We worked together very well.
Thank you. Yes, Jeff.
Just, and maybe John will too, I wanted to add another comment that I think some of you may have seen some of the maps that Nancy McCann was flipping through. I think you need to really keep in mind the land ownership pattern in this part of the Wind River drainage and the intermingling of fee and trust and private lands, federal projects, sort of added to the mix of the reservation is not in some isolated corner of the state. It is right in the middle of a huge economic machinery involving irrigated agriculture by Indians and non-Indians alike. And I think that pattern of ownership, the mixing and matching, I think was initially a real concern about what a different type of water right might do. We didn't know what the details of an attribute of a reserve right were. And you need to also keep in mind, before the adjudication and these assertions began, almost all of the lands, except for some of the futures, but all the lands that ultimately received water rights under the reserve rights doctrine all had state water rights. The federal government had applied for water rights with the state, had received the water rights from the state. They were relatively senior under the state's system, not as senior as 1868, but still relatively senior. So the idea that there's another set of water rights that nobody knew about, I think, created, again, another layering of this uncertainty. We thought all of the big, large BIA canal systems across the reservation had state water rights, and they did at that time.
Yeah, and just on that issue, kind of with things starting, I kind of can add to what Jeff and Sue said. When you're involved in the case for decades, you talk with some of the folks who were involved early on. And on the state side, another factor that was in their discussions was, do we get the adjudication started, or is it going to get handled in federal court? So that was some of their balance in trying to figure out how they were going to deal with the claims of the tribe. And from the tribal perspective, the state statute wasn't a total surprise. As I understand from tribal leaders, John Vintage, who was a state senator at the time, called Chairman Harris and said, look, I'm letting you know this is what's coming down. And as the tribe started dealing with the lawsuit, it would bring them certainty, but they also had some questions about the United States' role, which is why they intervened in the case, because not only did you have the United States as trustee, the United States also represented the irrigation districts whose water rights would be directly in conflict with the tribes, and that tension continued throughout the early parts of the case. I mean, the Department of Interior had an attorney for the Reclamation Department who was required to be at every hearing that the justice lawyer was at to make sure that the justice lawyer didn't do anything that too adversely affected the irrigation, non-Indian irrigation reclamation projects. And then as you get into the 1990s and the later part of the case, where reclamation is going out of the business, or there's not a lot of new dams to be constructed in the West, a lot of places where storage is going to occur would be on reservations, and you saw a change where they now were more being partners with the tribe than being adverse to the tribe. So those kind of early positions also changed over time.
Nancy, you want to chime in on this?
Yeah, what I wanted to do is say that Susan, John, and Jeff, when they were talking about when the quantification of the tribal reserved rights was being done, and then that resulted in Tino issuing his decree. What we didn't know to what was the real result of that decree. It's not just that total amount of water and the total amount of acres. What were those details? I think a lot of people don't know that when those water rights were being quantified, there were actually 56 sources and multiple tributaries that were having to be reviewed, and those sources and tributaries and the multiple tracts, there were like 1,700 tracts on different exhibits, different hard copy maps. There was no one central place where all these water rights were being. One thing that we've learned is that any decree that does get issued by any judge, any special master, one place that identifies all the key attributes of the water, where the lands are, how much water is, what the name of the ditch is, those key elements are important, because if you go back and you look at the decree that Tino Roncalio produced, what you will see is he does have the water amounts. And a lot of people don't know that, well, where's the tracts? Where's the land descriptions? Where's those details that Susan said? You have to know where they are. What does that mean so we can move forward to the future? And that's what had to be done. And that's where, when we did get into the GIS and mapping, once technology was finally arrived in 1986, and actually had look at those and put them all into one location, we started to see a pattern, and a pattern that we never realized, that, like Jeff alluded to, the ownership pattern, where the water rights were, the individual pieces, who actually had that water right. And there's tribal, there's trust land, fee land, and there's non-Indians out there, that it is all an integrated system. One ditch, many water rights. Visually is something that you really need to have to accompany any kind of decree that does get issued.
So you can see we've set a stage here where the state has looked at these claims, wants to resolve uncertainty, to protect natural master.
As we but problems get an entity from the beginning.
about as far as where we are going forward. But I think what you learn, and Susan mentioned it, is once one of these babies gets going, it is very hard to turn it off. And I think if we could do something different, obviously we needed to have better and direct and meaningful discussions. And we could, while there were a different, like I said, a variety of different shots at settlement, there was often just too much sort of litigation positioning in the room, and we could never sort of separate ourselves from the machinery and the very long, extensive, hard-fought Big Horn 1 set of trials set a bad tone that took a long time to overcome. And I think if you could have established a different dialogue, a different level of trust earlier on, I would have loved to have done that, because as others have commented, when you go to court, you do get a decision, whether you like it or not, and there are winners and losers, and there isn't a decree written yet that is going to be that clear. So you get the decision, and then you're immediately fussing over what it means. And so the only way to break that chain is with greater dialogue.
Ramsey, I would like to add to what Jeff just said. What I found the most useful, and we probably should have done it from the beginning, is actually work together on the ground. I think we have benefited so much from joint inspections on Phase 3, all the Bureau of Indian Affairs projects. We work together to help that happen. And I think that helps us not only get to know each other on a personal level, but it also helps us to understand the points of view. And that is the key, is to understand the different points of view. You don't always have to agree, but definitely understand the point of view and have mutual respect for each other. If we could have done that early on, I think that would have been most beneficial. It just, I mean, communication, I can't say enough about having the communication continue moving forward. I think that would be the best thing that we could ever do.
Thank you. Susan, how about you?
Well, I concur with both Jeff and Nancy here on those elements. And I think that, I don't know that it's something we can do over, but I wish we were able to do better early on, was to actually listen to each other. You know, like Jeff said, we were in so much litigation that it was kind of hard to sit down and talk about, you know, anything other than our legal positions, and we didn't want to give up our legal positions or, you know, compromise the tribes in any way. So that, on the other hand, you know, there's ways to protect what you're doing in negotiation, and that's something I wish we had commenced a little earlier too, and it kind of goes along with what you were saying. It's just, let's listen to each other, talk together.
Terry, from the court's perspective, is there something you would have changed, done differently?
Well, first of all, let me congratulate the state of Wyoming legislatures for funding this process. I still haven't heard a total cost, but I know it's going to be significant, and they're very brave to have continued that over the years. But it was also important for the state and the tribes to begin working together, because just to understand each other. In the Idaho case over there, we've worked with the Nez Perce, the Shoshone Bannock tribes, the Shoshone Paiute tribes, and the northern band of Shoshone. We've got more tribes over there than you have here. And it's been a real privilege to work with them. But it was also a privilege to work with and get to know the tribes here, and especially to know their history. During the case, early on, and I wish we'd done it earlier in the process, was to get to know the background of the tribes and the treaties. A lot of misunderstandings could have been avoided if we had only gotten to know everybody better. And the tribes have got this enormous history that hopefully the state has fully comprehended now, and I understand they have, and it looks like it. But I would encourage whoever's going to talk about tribal water rights is to get to know the tribes and not to know the tribal attorneys necessarily. Let's bring the tribal leaders in. I want to find out, as a special master, what the tribe leaders want, what their understanding is, what their beliefs are, because that helps the court understand just how important these water rights. From a lawyer standpoint is one point, but from the tribal standpoint, I wish we had gotten that earlier on.
Thank you. John, maybe you can talk a little bit about one of the topics Nancy touched on. One thing we've noticed over time in this case, of course, you all have in your lives, is that technology has grown exponentially, and our ability to leverage that to help people understand Indian water rights, non-Indian uses, irrigation districts, all those different rights and uses has been with technology. And maybe you can speak to how that's kind of changed the way the adjudication went over time.
Yeah, I don't know what I call it, the privilege, but of having to go back through the early history, even before I was in the case, because in later proceedings you had to figure out what did the court really decided or not decide. And when you go back and you look at the technical work, you have aerial photos and maps that are hand drawn on individual parcels, and they're about as big as these computer screens. And there's just boxes and boxes and boxes of those. And someone had to go through and do all of that, and then the other side was doing the same thing, and then they'd have to get together. But actually, they didn't get together to really compare those. They argued from those in front of the court. And so I would echo what has been said here is what we did later in the Walton cases was we sent both parties out to look on the ground at the same time so that they were seeing it. Because if you look at a parcel of land in May and you look at it again in October and November, you might see different things. So that we sent people out on the same day and put down that information, because in the early part of the case there was a lot of fighting about discovery, who got access to the land, and then what were they looking at versus what the other side was looking at. And so the technology as it developed, one is it was easier to share with the other side your information. So instead of having to go and ship copies of those exhibits, and I think there ended up being probably 4 or 5 sets of each of those exhibits to circulate among all of the parties, is you could then send it on a CD to somebody. You now can send it through email. But you also, with the technology, it let you compare 2 sets of information very quickly, because when you have two pieces of digitized information, two maps, you can overlay those and see where they match and where they don't match. The technology with the mapping now is you can visualize what's going on the ground with the respective water rights, which helps everybody's understanding. Because when you see a given parcel, not just a given ditch, that has, the owner has a tribal reserved water right, they may also have a state water right, and you see what their neighbor has, you see the dynamics of how are you going to administer this. And so that technology has removed some areas of disagreement because you aren't disagreeing on the facts, so that when you've got a problem, you can focus on what the law is. And also that technology, if you get an irrigator today who comes to the tribal water engineer and says, my neighbor's taking my water, the tribal engineer can pull up those water rights electronically, and he can email the state engineer and say, heads up, we've got an issue here, we've got a state right, we've got a tribal water right, and the two of them can readily have this, be looking at the same information and focus on what the problem is. Because many times the violators of a water right, people are using water they're not entitled to, they aren't so concerned that the tribe is regulating them or the state is regulating them. The fact, what they would like to do is play the two off to the other, because while the two of them are fighting and can't resolve it and have to run to court, the irrigator's been using the water for 2 years, and the increased communication and technology has actually let the two governments look at the issue, and I would say in probably at least 90 to 95% of the cases, the governmental officials agree on what the answer is, tell the irrigators that, and you can move on. And that couldn't happen before, when people didn't have the ability to readily share the same facts on what's going on the ground.
Thank you. Nancy, you have been very involved with the technical background, so maybe you can speak to it as well.
Okay. One thing that we found out through the use of technology, when you actually have to start mapping out the results of the Tino decree and seeing those locations on a map, you quickly start to realize, because of the different types of tracts that he awarded, and they're shown on different exhibits like I alluded to a little earlier, there were adjudicated tracts, unadjudicated and used tracts, type 7 tracts, type 8 tracts, Indian fee tracts, and of course the futures projects. So once you see those all on one map, not only do you see that they're all next to each other on that same ditch, but you also know by referring back to the decree that each of those types of tracts actually have different water duties assigned to them on the same ditch. And that's a very interesting thing to actually see and understand, that it's not just that one tract that had 4.6 acre-foot per acre per year, but the tract right next to it and adjacent to it is a 10.55 tract, because it was a different type of award that was given under the Tino decree. And so to try to show that in an aggregate way, to correctly and properly demonstrate or show the mapping of the tribe's rights, it was interesting. I mean, I just can't say enough about the use of technology and what that means. But on a governmental aspect, I want to say that because the state worked on that project, that doesn't mean that it's just the states, just because we are a party. What we thought and we advocated is that this information should be shareable. We're a governmental entity, and we did share that information with the tribes. At one point, we did enter in, as Pat Terrell alluded to, a data sharing agreement between the state and the tribes. And we had that data sharing agreement for a period of 5 years. I think that was the contract time. And but even though that agreement had expired, that does not stop us from sharing data across to the Tribal Water Engineer's Office, over in addition to the Bureau of Indian Affairs, to work together so we all have the same base that everybody has agreed to. And it's not just because the state said, oh, this is the data. No, all the parties had to review all this technical data, the GIS, the databases, all those components. And the day that I finally received the letter from Jim Clear, and it said, because he had all his technical people reviewing all the data that the state was producing, he said it's 99.9% accurate. Go ahead and share it. That was probably the most exciting day. I went ahead and treated myself to a McDonald's hamburger that day. And boy, that was the best burger I ever had.
Thank you, Nancy. So looking forward a little bit, I'm going to ask some of the panelists to maybe foreshadow upcoming issues. This adjudication's come to a close, and changes of water rights and things that are out there still will happen in the future in a different way. I'll start with Special Master Dolan, because about a few weeks ago in the Snake River Basin adjudication, they also finished up that water adjudication in the state of Idaho. So he has some perspectives on that.
Thank you. I guess everybody knows we finished ours last month, and 10 years before you, the Idaho adjudication.
They had more special masters and a dedicated judge. Just saying, different resources.
We had 3 special masters over there and just 1 here. By the way, when I first started with Judge Hartman, he appointed me to a special master for Phase 3, and he said, you're going to be working for 3 years. After 7 years, and working with Gayla Mead back there, it took me a while to figure out this is going to take a little bit longer than what I'd planned. So that's when I ended up moving over to Idaho. But when Gayla Mead and I started off, we had one computer, and I don't know what the capability was, but it was about what the capability of my wristwatch is right now. Every time we had a water right claim come in, we had to double check it quarter by quarter, and then we'd retype it, not on a computer. We'd send it down with a final order to the engineer's office. They would have to proof it. And if there's a wrong, they'd send it back to us. We would proof it. Times have changed. And by the way, your general adjudication over here has given you a wonderful capability of understanding your water rights. Farmers understand maps. Now you can go to your GIS system, look at the actual land that you have, and I say GIS, that's a picture of what your land looks like. You can see your house, your barn, you can see your road going to it. Knowing that, and then understanding what your water rights are on another layer of the system is absolutely wonderful. But in the future, you're going to face a lot of issues with transfers. You're probably going to have cases come back to the court for whatever appeals. Court oversight is what we call it. You could end up facing an issue on the Bear River Compact, because eventually Idaho is going to probably sort of maybe adjudicate the Bear River area. We haven't covered that. We've got, let's see, 5 different basins. We've got 3 more to do up in North Idaho, and then 1 more down the Bear River. So you're going to be looking at your compact all over again. But the issue we're facing now over in Idaho is how to handle conjunctive management, the effect between groundwater and surface water. But again, let me congratulate you on you've got a final decree now that defines all these water rights in this basin, this portion of the state, and you've got a workable tool. And the important thing, and this is always something I've kept in mind, whatever we do, the farmer has to understand his own water rights. Not the lawyer, not somebody to explain it to him, but the farmer has to go out there and look at the land and understand what he can do with his water.
Thank you, Terry. Maybe Jeff, you can speak a little bit to the same question. Since you're in a consulting capacity now and we're formally a policymaker, can you foreshadow issues that you see maybe out there for this water division?
Well, obviously you need a consultant, right?
Oh, there you go.
No, I think we've said a lot of the same themes and talkings. I think clearly all of this will shift to sort of implementation role. There's going to be continued issues of administration, of changes to water rights that are going to have to be worked on cooperatively. It seems like data sharing is going to be key. The technology obviously is there, but the parties or the Tribal Water Office and the State Engineer's Office need to be communicating as much as they possibly can on the information, the facts, as each party understands them, to avoid triggering some new discussions. So I understand that there have been some changes to the water rights since they were first adjudicated. The Board of Control has handled a couple of those already on some isolated cases with individuals moving the water rights around under the processes of state law, and whether that continues or to what degree is, I think, a good thing. And I think there's a lot of studies going on, have gone on, continue to go on, dealing with new development, new water development, new storage, I think, to some degree is going to be critical, because I'm not sure much in 37 years has changed on the ground. I don't know if the total number of irrigated acres that you see today in the Wind River and Big Horn Basin entirely is very different than it was 37 years ago. So hopefully with the final decree, with the certainty that 37 years ago was sought is now known, that you can look forward, you can look to putting water to use in an economically viable way, in a cooperative way. I think many hydrologists believe, water supply experts believe, that will require storage, some new storage development to take advantage of the huge variability in hydrology in this basin. We'll have one year where there's 100 CFS in the Little Wind, and the next year there'll be 10,000. And that's just the nature of the snowpack ribbon runoff that we have here without a lot of storage. So I assume that will clearly be an issue that'll be continued to be wrestled with, I think.
Okay. Susan, can I ask you to talk about administration a little bit too, since you were so involved with the litigation about that, and key actions that may increase cooperation, effective water administration? And I know you've talked about communications, but other insights would be great as well.
Well, I think that one of the things that we have to do is look toward the future, and in that regard, the tribes have a very large asset here. That's that future water right. And, you know, the initial efforts to put it to its highest and best use failed. But, you know, like John Schumacher said, the court in Big Horn 3 was all over the place, so heaven knows exactly what they held. But they certainly concluded there was a sort of a bare majority of feelings for the notion that the tribes, if they wanted to change their water right use from agriculture to in-stream flow or you name it, that the tribes first had to put the land to use, agricultural use, and then under concepts of state law, transfer the use of that, meaning you don't want to injure, you know, people that have been using the water previously. So what these water engineers, state and tribal, have to do is figure out if that issue comes up again, you know, at least we now can talk to each other about it, you know, and really honestly and in an open-minded way look at the data behind the proposed transfer. But you know, whether or not the Big Horn future projects will ever be developed agriculturally is an unknown. And as from our history, we know that there might be other uses. So I think the transfer issue is going to be a big one moving on into the future. The other is looking even way into the future, although it seems like it's getting closer and closer to us, is that the general water supply issue here, you know, a lot of people are beginning to become aware of the effects on water resources of global warming, climate change, and certainly the Colorado River Basin people are very concerned about this. So, you know, these are things in the future we just got to get our head around and understand and begin the process of the research and data collection necessary to understand what's happening, because reduced water supply hurts us all.
And I would add a couple of in my view, pragmatic things that I see from working on the ground. One that's going to come up is the state and the tribes figuring out how to measure the water uniformly. You have a volume right, you have a rate right, as Mr. Terrell said, and no matter who's administering a given parcel, that's just inherently unworkable. You're measuring some people by volume, you have instantaneous flow rights that are going. So, if I'm a farmer, how do I know when I've used my water right? So if I have a parcel and half of it's 1868 and half of it's state rights, and that kind of scenario happens in instances, if I start diverting in the springtime when the water flows are high, well then am I using my state water right and the surplus flows, and so I can use over my 2 CFS if there's water in the river, and then am I holding my reserved right till the end when there's a water shortage, or is my reserved right count at the beginning of the summer and then I can only use my state right after the volume of my reserved right? It just, it creates a situation that if you're trying to go to the court, you can't say somebody's taking my water because it's hard to prove who took what water. So I think that's something that's going to have to get resolved. And then, as people have talked about, how is the water use going to get changed, is having to resolve the question of what is the consumptive use for the various parcels, because the award is a diversion right, and in reaching that diversion right there was some technical work, if you go back to the expert reports, about what was the need for the crops, the losses in the system to get to that diversion amount, and that needs to kind of go back and get extracted out so that if I want to put my water to a new use or I want to change it, we know what it is that's being used, because as one of the earlier speakers said, the award is, I think John Waschke said, the tribes can use their water for whatever use as long as they don't increase the consumptive use. That's a different number than the diversion amount. So I think those are two practical things that'll have to get resolved between the parties. And then a third thing that I think in practical terms they need to work on together is getting the water to use, whether it's through storage, whether it's 1868, whether it's state rights, because even though the reserved right isn't subject to abandonment and the state has compacts with other states, the reality is if water starts getting short because there's just not an available supply, if you're not using it, someone is going to find a way to take it away. And as tribal members, the number of votes you have is small compared to non-Indians, so that you get Congress or somebody taking it away. But as far as Wyoming is concerned, our numbers are very small compared to downstream users. And if we're not using and controlling the water, I think there's a chance someone's going to take it away. And I think both Wyoming and the state have a common interest, in particular because the reserved rights aren't counted, as, if I'm reading it correctly, against the Yellowstone Compact. So that keeps more water by the tribes using it to develop the economy within this state, and that benefits everybody.
Thank you, John. Will you all join me in thanking this panel? You can tell the devil's in the details, and they know. Oh, sorry, Nancy, do you want to add one closing remark?
Well, I wanted to put the icing on the cake,
okay.
if I could.
Ready? Icing.
Okay. One thing that I'd like to leave this symposium with and have everybody understand is that you might have litigation, you might have settlement, but we never talk about a water management plan where we're all working together. And one thing that Mr. Pat Terrell has taught me over the years, keep your eye on the prize. It's not that somebody wins or loses, is did you work together and did you accomplish the goal together to get to that end result? And I think a water management plan could help us for the future, working together, what do we want, rather than fighting it out in courts or even trying to be focused on settlement, which could take years. And we did that in a way, we focused on what the end prize would be to get us to this day when the parties all did get together with the courts to put together of what the final decree was going to look like. That was a plan towards an end goal. And we had John Thorson come in and work with the parties, and everybody had their opinion and input contributing into that plan document. And that's why I think we got to where we were.
Thank you. Okay, now you can join me in thanking the panel, and then I'll let you know. Okay, this is the morning 7th inning stretch. You can stand up and stretch, but don't go anywhere. I'm going to ask John Thorson to join us at the up here at the podium, and he'll talk to us about the regional perspectives of general stream adjudication. So stand, stretch, and then pay attention again. This is just like when you're in middle school and the teacher says, I know you need to stretch a minute, but then sit down. Thank you all.
I'm James Wynn. We spoke on the phone a little bit ago from Waffle. Hey, how are you?
Good, how are you?
Pretty good. Yeah, you bet.
Okay. Back and forth. Does not work so well.
Okay.
Okay, your stretch is over. One good thing that you learn when you're sitting behind the bench as a judicial officer is that you can speak loudly and get everybody to fall into line sometimes. So if you could all end your conversations, we'll have a break after this next presentation. And if you could turn your attention up to the stage, we can begin with our next speaker. So we'll have a break after the speaker, so if everyone can settle into your seats, that would be great. It gives me great pleasure to introduce John Thorson. John is the water master for the Lummi tribe, federal water master in the state of Washington. I first got to know John Thorson as his employee when he worked in the general stream adjudications in Arizona, and he hired me out of law school, and I have been fortunate to follow in his wake ever since and have tried very hard to keep up as hard as I can. He's worked in water rights in Arizona, in New Mexico, in California, in Washington, throughout the Missouri River Basin, and he's going to speak to us this morning. Please join me in welcoming John Thorson.
Thank you, Ramsey. And thank you, University of Wyoming School of Law, for the opportunity to be with you today. Professor Robinson, thank you for the invitation. You, along with Professor Michelle Mudd, who's here today, and Barb Cousin from the University of Idaho School of Law. These three young professors are really creating centers of excellence in water law in the Rocky Mountains. I know it's difficult to listen, and it's also difficult to speak on 9/11, because I think our minds are full of memories of 13 years ago, and I suspect that the skies were weeping this morning. Just a quarter of a century ago, June 1989, I had the opportunity to attend a conference on Indian water rights and water management at the University of Montana in Missoula. It was put on by the University of Arizona, as it turns out, but the conference featured Special Master Tino Rucalio, the former Wyoming congressman who served through the first two phases of the Big Horn adjudication. This was during the heyday of these large comprehensive adjudications, and this conference was well attended from around the West. For me, the highlight of that presentation by Master Roncalio was the description of all the work that he and the parties had been through, and you've heard some of that this morning. 45 weeks of trial, 14,000 pages of transcripts, 2,000 exhibits. And with mixed regret and satisfaction, Mr. Roncalio indicated that all that work had come down to just 10 words. The judgment below is affirmed by an equally divided court. The reference, of course, was to the U.S. Supreme Court's decision in Wyoming versus United States, which affirmed, as you've heard this morning, the state Supreme Court's determination of tribal water rights on this reservation. I left that conference thinking how exciting it would be to serve as a special master in a comparable proceeding. And only a year later, I had the opportunity to be appointed as the special master for the Arizona General Stream adjudications, the Gila adjudication, and the Little Colorado River adjudication. While I was never able to match Master Roncalio's contribution, I did, in my 11 years of service, engage in some of the most exciting and intellectually challenging endeavors since graduating from law school. And certainly my best decision during that period, and pleasantly ironic as it's turned out, was to hire Ramsey Krupp as my staff attorney. And she's made an enormous contribution in almost 20 years of service as your special master in this litigation. I also want to acknowledge Judge Gary Hartman, formerly of the District Court, Division 5, who often attended programs of Dividing the Waters, which is a program, an educational program for state and federal judges involved in general stream adjudications and other complex water cases. Judge Hartman shared his expertise and experiences here with his colleagues from around the West. He also gave me the opportunity to work with Master Krupp, as Nancy McCann has indicated, in developing a plan with the attorneys for the conclusion of this adjudication. And I was very pleased to learn today that that plan was implemented, culminating in the final decree last Friday. So I do want to thank the officials of the State Engineer's Office and the attorneys involved from the tribes, water users, and federal agencies in that endeavor. Driving down from Missoula area yesterday, it was clear that this is harvest season. And this is a season for celebrating the harvest. And certainly it is a season for you all to celebrate the conclusion of the Big Horn River adjudication. It's taken many years, many challenges, many periods of productivity and drought to accomplish this final decree. And I know it's not been an entirely happy and collegial journey, but I think many of the disagreements will disappear over time as the larger vision is realized. You've not been alone in this endeavor. You've heard already about the Snake River Basin adjudication being concluded in a final decree last month on August 25th in Boise. And Judge Wildman, Eric Wildman, of that adjudication sent some photos. This is the signing ceremony on a Monday evening in Boise with several governors and a former Secretary of Interior in attendance. Fortunately, Judge Wildman, who probably was not alive when the Big Horn adjudication was underway, didn't bring all the attachments to the decree. Here are the 250,000 pages of attachments to the final decree in the Snake River Basin adjudication. Justice Anthony Scalia also spoke at that signing ceremony in Boise. He talked about the importance of his court, but he also emphasized that for most people in America, the most important court is the one down the street and in their neighborhood or in downtown of their community. And for the people in this region, for the last 37 years, the most important court, I think, has probably been the 5th Judicial District of Wyoming. My task this morning, in the minutes I have, is to first trace the genesis and the current status of these large adjudications throughout the West, and then secondly, acknowledging that these things are never final. You reach a measure of finality, but additional challenges remain. In that spirit, I will talk about some of the challenges that are ahead for you and others in the West who have been involved in these cases. Let's talk about the genesis of these stream adjudications. By 1867, this landmass of 1.7 billion acres had been gathered together by the federal government, the public domain. And even as that land had been finally put together, efforts were made to dispose of the lands. And between 1867 and 1934, about 700 million acres of that land were transferred to private parties, to state governments, and other grantees. Also during that period, we saw radical changes of Indian policy in the United States. From a period of treaty making to a period of removal of eastern tribes to western reservations and the relocation of western tribes as well. We saw the allotment period and emphasis on assimilation of tribes into the larger community. Fortunately, a policy that was ended. But during that period, there was also a long saga of the West searching for adequate institutions and laws to manage water. It's been a 150-year saga, starting in Colorado and Wyoming, and eventually spreading throughout the West. Let me give you a few examples of that saga. In the late 1800s, this huge landmass, 1.7 billion acres, it came with assumptions that the riparian doctrine of the eastern states would apply. But that water rights doctrine was ill-suited for the West. Consequently, citizens in California and Colorado and other places developed a different method of water allocation based on priority, the priority that we know as the prior appropriation doctrine today. So there was that adaptation to the realities of the West. Also in the late 1800s, it became apparent that the settlers didn't have the resources, neither the capital nor the labor, to adequately develop and distribute their water. So in response, the adaptation was to rely upon community-based organizations, private water companies, irrigation districts, mutuals, eventually California's Right Act, eventually the Reclamation Act of the federal government. So another adaptation to the realities of the arid and semi-arid West. And then at the turn of the 20th century, many of the tribes and their advocates became concerned that the natural development of the prior appropriation doctrine would be to limit and deprive many of the reservations of adequate water for the tribal futures. The adaptation was pioneered by the federal courts in Montana in a case called Winters that was affirmed by the U.S. Supreme Court in 1908. By the 1930s, there was the concern about the need for more comprehensive planning in our major river systems. The adaptation was the Tennessee Valley Authority, the Pittsloan Plan on the Missouri, the Columbia River Project, the Colorado River Basin Storage Project. And even as late as the 1980s, there was concern about how states could recognize historic, important public values in water. Colorado passed an in-stream flow statute. Montana Supreme Court recognized the public trust doctrine as recognizing and protecting recreational uses of water. And California recognized the public trust doctrine as pertaining to all water right allocation decisions. So as the Idaho Director of Department of Resources mentioned in Boise just a few weeks ago, we've always come down to the wire in the West, but we've always found a practical way. However, this quest for appropriate laws and institutions in the West for managing our water has encountered many barriers. There has been, of course, the huge land base involved and the major systems of rivers that transect that land base, the Missouri, the Columbia, the San Joaquin River, the Rio Grande, the Colorado, and others. There's been the interjurisdictional nature of the West. At least 17 states, depending on how you describe the region, at least 277 tribes in those states. And again, interstate issues concerning water and the alphabet federal agencies that are involved in water management in the West. There's been the unresolved federal tensions that have existed since the first days of Western settlement as to what the appropriate roles are for the federal government, state governments, and tribes. There's been inadequate science, and even when the science has been known, the difficulty of employing or incorporating scientific principles into water laws and institutions. I only need to point to Arizona's struggle with something called subflow, a somewhat fictitious concept to indicate the difficulty of relying upon good science. And the West has become more heterogeneous as the generations have gone by. And these different populations have different values concerning water. But let's return to the late 1800s for a moment, where the challenge was how to sort of address a patchwork of unrecorded water rights, local decrees that were not adequate, and other problems of water management. Between 1879 and 1881, Colorado developed an approach to that issue, which was the establishment of a predominantly judicial system to manage and adjudicate water and to provide new uses. Colorado was depending upon sort of the expertise, the independence, and the legitimacy of court systems to make those decisions. By contrast, Wyoming took a different path, as you well know here in this room. Under the leadership of Elwood Mead, water decisions were vested in an administrative structure, a state engineer, a board of control, relying upon the expertise of those individuals and the expediency that that process would allow. But between those polar approaches, other hybrids developed, with some states emphasizing a judicial process and other states emphasizing an administrative process. But most of these states had some procedure for a statutory adjudication. These statutory adjudications in the early days were used for a variety of purposes. They were used by some states to integrate the riparian rights with the prior appropriation doctrine rights, such as happened in Nebraska. These adjudications were used to firm up existing water rights that were being pledged for federal reclamation projects, as happened with the Salt River Project in Arizona. These adjudications are used to determine groundwater rights, as was the case in Southern California with adjudications of the Raymond Basin, the West Coast Basin, and the Central Basin. These adjudications were used to integrate surface water and groundwater rights. And finally, they were used in some states to shore up supplies for municipal growth, such as for Oklahoma City and Tulsa. But in the post-World War II period, these statutory adjudications proved inadequate for several reasons. First, the courts lacked sort of the sufficient resources and the procedures to bring all the necessary parties together in one courtroom in one case. And more importantly, if the case involved the water rights of federal agencies or tribes, states courts could not assert jurisdiction over those entities because they would claim sovereign immunity. This last issue became very controversial in the early 1950s. In a small adjudication in Nevada, the Wind River adjudication, there was a concern about bringing the Navy, of all parties, into a small adjudication concerning its water rights. Senator McCarran took wind of that and cleverly associated that issue with a controversy in Southern California, the Santa Margarita controversy, where the federal government had sued several thousand local water users in an effort to establish water rights for Camp Pendleton. Those two episodes in Nevada and Southern California combined to create enough political will in Congress to pass the McCarran Amendment in 1952. And that amendment, as you know, waives sovereign immunity for the adjudication of federal reserve water rights in a comprehensive court proceeding, whether it's a state court or a federal court. But it wasn't until Arizona versus California, decided by the U.S. Supreme Court in 1963, that it became clear to Westerners about what the extent of these reserve rights could be. That case recognized the practicable irrigable acreage standard as the means for quantifying tribal water rights, and it suggested these rights were assertable by federal agencies in addition to the tribes. These considerations were supplemented as we turned into the 1970s by growing Western population, rapid energy development, and that lingering problem of having inadequate water right records in most of the states. What transpired was a race to the courthouse with federal agencies, Department of Justice, Department of Interior, trying to get into federal court at the same time states were trying to get their state adjudications underway. By virtue of a trilogy of U.S. Supreme Court decisions, that race was generally won by the states. But I must say that that result was not necessarily favorable for all the tribes. I think some tribes, as I understand, wanted the ability to establish their water rights. Other tribes preferred to wait maybe to some date in the future. And finally, other tribes thought the idea of adjudicating water rights was just a concept that was foreign to their belief system. Well, so these adjudications, these large McCarran adjudications were established in the 1970s, early 1980s. What were their primary purposes? Master Krupp mentioned those this morning. To recognize valid existing water rights. Secondly, to adjudicate, determine, and integrate the federal reserve rights into a state system. And finally, to create better records, a comprehensive set of records concerning water supply and water demand. Well, here we are 25, 30, 35 years later. What's the status of these cases today? Fortunately, this afternoon, we have a very talented and experienced panel. I think the experience exceeds probably 100 years of experience in these cases. They will tell you more about the adjudications in Idaho, Montana, Arizona, and New Mexico. What I want to do is kind of give you a very brief summary of the adjudications elsewhere in the West. That chart is somewhat hard to see, but I will describe it here. And this is rather arbitrary, kind of based upon my own sort of personal judgment. But there is a category of somewhat finished adjudications. Certainly Idaho's Snake River adjudication falls into that, and now Wyoming's Big Horn adjudication as well. Colorado has continued its ongoing adjudication process since 1879. They've also been benefited by one Indian water rights settlement concerning the Colorado Ute tribe, and that settlement was dated in 2000. The state of Washington is finishing up the Yakima adjudication, which involved the reserve rights of the Yakima Reservation. Additionally, there was a federal court proceeding that resulted in the Lummi Decree, a small groundwater decree on a peninsula north of the Seattle area. I don't know if you can see this, but Washington State has a variety of other adjudications underway that don't involve those extensive federal claims. They've completed 82 adjudications of smaller basins. There's apparently 7 underway, and they have petitions from water users for adjudications in 66 other watersheds. There's also a category of adjudications, I guess I would call just major McCarran adjudications underway. That would include Arizona, Montana, New Mexico, which you'll hear about this afternoon, but it also includes Oregon. Oregon has had an ongoing Klamath River adjudication involving the Klamath Reservation. That has been underway since 1975 to the present. The Department of Water Resources in Oregon has just completed its administrative determinations. Those documents have been shipped off to the state court for that phase of the adjudication. They have had one settlement involving Warm Springs, the Warm Springs Reservation, and they've completed about 55 other smaller adjudications. About 50% of the state is involved in those adjudications. Then there's a category of adjudications that are sort of targeted, ongoing adjudications, sort of at a slow pace. They involve California, Utah, and Nevada. Nevada has completed about 50 adjudications and has about 50 underway. They've had 4 Indian water rights settlements. They pertain to the Fallon Paiute Shoshone tribe, 1990. Truckee Carson Pyramid Lake, 1990. Shoshone Paiute Tribes of Duck Valley, 2008. As well as the 4th settlement being the Las Vegas Paiute Tribe, 2002. Utah, which is this slide here, has an adjudication of all of their basins. They're currently working in 5 adjudication areas today, which are identified on that map. They've had one settlement, the Ute Water Rights Settlement of 1992. That has not been approved by the tribe or the state. California, somewhat difficult to see, but in Southern California, we've had statutory adjudications of groundwater basins. I mentioned some of them earlier. And in the northern part of the state, a series of statutory adjudications. California's had 3 Indian water rights settlements involving the San Luis Rey tribe, the Truckee Carson Pyramid Lake tribes, and the Saboba Band of Lusueno Indians. And finally, some states are even considering new adjudications, as hard as that is to believe at times. Idaho is going to be commencing an adjudication of the Coeur d'Alene area, and that is triggering an adjudication by the state of Washington, most likely, of the Spokane area, which adjoins the Coeur d'Alene area in the northern part of the state. As Ramsey mentioned, Oklahoma is starting an adjudication of 3 watersheds in the southern part of the state in response to federal lawsuits by the Choctaw and Chickasaw tribes. So, given that status, how are we doing in terms of those 3 stated purposes for water adjudications? Well, remember the first purpose, recognizing existing water rights. Well, the news is mixed on that, generally good, but mixed. The agencies and courts, I think, have done an admirable job of weeding out the bogus, exaggerated claims. And we do have the documentation we didn't have 20 or 30 years ago. This should encourage or facilitate water right transfers, which is something many economists have urged, although many of those transfers will continue to be challenged upon environmental law grounds. And there are large classes of water uses that have been left out of these adjudications, and these may prove troublesome in the future. Some uses have been statutorily exempt, others have been deemed de minimis. Groundwater in some adjudications has not been included. But again, in terms of existing uses, documenting those uses, the news is generally good. The second purpose was to recognize, quantify, and integrate those reserved water rights. And this is generally good news as well, although once again recognizing that some tribes did not want to participate at this time or ever. But the story here is surprising. 30 years ago, we thought that we would have extensive litigation, take a long time. The tribes would have very large paper awards of water, but little would change on the ground. Almost entirely the different thing has happened. We've had negotiation, almost 35 settlements in terms of what I've been able to count of Indian water rights. This has resulted in an influx of federal and other dollars into areas for water development and economic development. For instance, the Gallup Navajo Nation settlement in New Mexico is budgeted at over $500 million. Also, as a result of these settlement activities, there's been a basis for greater collaboration among all the parties, as you've heard during the earlier panel. And these settlements, in many cases, like in Arizona, they've helped secure long-term water supplies, not only for Indian communities, but for surrounding non-Indian communities as well. The third purpose, developing good water supply and water use data. This is all good news. You heard earlier about the technology. It's technology that we could not have conceived of 30 years ago. The geographic information systems, the remote sensing, the Google Earth, all these technologies make it so easy now to access these water right records and how the water rights are being applied on the ground. But what does the future hold? The previous panel mentioned many of these things and others. We've been able to address these problems well in the past, and I think we will be able to as well. But it would be an illusion, I think, to believe that we've made things final. Indeed, once we've reached one of our goals, in this case, the adjudication of water rights, we now recognize there are many other challenges in our future. And in Wyoming, as well as many other states, I think some of the challenges are these. To somehow pass the collaborative atmosphere that's been attained in these cases onto another generation of water users. The panel before us indicated how well they've been able to work at the result of this long endeavor. Now, can they pass that collaboration off to another generation of water leaders? We have the federal environmental water rights that exist outside these state adjudication systems, and how will those play in terms of water management? We have pervasive drought and climate change. That will change the assumptions on the ground in terms of water management. We have challenges concerning groundwater and surface water interaction. We'll have existing water right transfers, and those put pressure upon areas of origin and rural communities that are targeted for water transfers. And we'll need to enforce these decrees. And enforcement may be a great issue when we deal with a population now that is more urbanized, a population that may have different notions of how water should be shared in times of shortage. I only need to refer you to California's recent experience, where the State Water Resources Control Board recently sent out 20,000 curtailment orders in Northern California, orders that were largely ignored by the water users. What's the state to do? So the decrees in these adjudications, like the Big Horn adjudication, will provide some sidebars to these and other issues. But we've clearly reached another generation of problems, another plateau of problems that we'll need to address more creatively and with more understanding than we've been able to muster in the past. I want to thank you. I want to congratulate you on the completion of this decree. I wish you the best in terms of successful collaborative management. But I want to urge you to remember that the harvest, during this harvest period, that sustainable growing fields and gardens really depend upon perpetual care and ongoing attention. Thank you very much.
So there may be two ways to find out everything you ever wanted to know about water law, at least in the United States. One, the internet. The other, just call John Thorson. Thank you again, Federal Water Master Thorson, for speaking. We will have the good fortune of Mr. Thorson leading a panel focusing comparatively on the adjudications he referenced a second ago, those in Montana, Idaho, New Mexico, and Arizona. That will take place after lunch. We'll reconvene for that panel at 12:45, so in roughly an hour. For folks who've purchased tickets for the lunch, please feel free to get in the buffet line. We'll take those tickets there. For those who've not chosen to do so, there are several options for food throughout the casino. The Red Willow restaurant in the far corner here is an excellent option. But please go your separate ways as far as dining, and we'll see you back here at 12:45. Thanks.
Hey, James Wynn with Wildfile. We try to connect
Yes,
if any
right.
that work out.
Nice to meet you in person.
Yeah, nice to meet you as well. Things seem to be going great.
Yeah, I'm pleased on all levels. The facilities, the tribe has done a really, really good job, and nobody's dropped the ball on the program yet. Panelists or speakers, everybody's been really solid.
Yeah,
so if I weren't so hung up on my administrative stuff, that offers to sit down and chat with you.
I understand.
But at some point, we should.
I agree. Yeah, that'd be great.
Good deal.
Okay, yeah, nice to meet you.
I failed to mention one logistical thing. For those who are interested in purchasing lunch tickets and haven't yet done so, you can do that. Back table. Only caveat, we're only capable of accepting checks or Visa, checks or credit cards if you want to buy lunch tickets for the buffet, but that's at the back table.
Lindsay, can I have the thumb drive with your file on it? I want to give it to Christine and post it to the website.
Okay, so it has all my notes in it. Let me put it into a PDF.
I'll shoot you an email then. Would you mind
Yeah, I can give it to you.
later?
I've got my computer right here, so I can get it on my thumb drive. But my thumb drive is still in the machine?
There. No, I set it next to the machine.
Okay, great. Thanks. So I'll do that and then give it to her. I have all my, blah, blah, blah notes that I've... Okay.
Sounds good.
If I hadn't, then I'd have
gonna go over there. Yeah, sure. So.
Excuse me. Time is about up on the lunch break. If you could get back to your seats over the next minute or two, that'd be much appreciated. We're going to reconvene with a comparative panel. Please take your seats if you would.
If you'd like to take your seats, we'll get underway with our afternoon panel, please. This is our comparative panel, looking at the status of adjudications in 4 western states. We have a distinguished panel, as I mentioned this morning. I think the total experience in stream adjudications probably exceeds a century among the panel members. Our format this afternoon will be to start with a series of profiles, roughly 15 minutes from each of the states. The panelists will talk about kind of the basic characteristics, the jurisdiction, the number of parties, things of that order. We have some maps here. During the next part of the session, we will address some questions to each of the panelists, similar to the morning panel, to kind of get out the contrast and comparison of some of the issues. And then we would like to try to reserve about 15 minutes at the end of the session for questions from the audience, or failing that, some more exchange between the panel members. As I said, a distinguished panel. I've had the opportunity to work with all these individuals. We're going to sort of take these panelists in the order of their adjudication, when sort of the major phase of the adjudication got underway. I'll give the introductions for all four now, and they'll just come up individually thereafter. We'll first hear from D.L. Sanders, who's Chief Counsel with the New Mexico State Engineer's Office in Santa Fe. Originally a native of Detroit, he soon found his way west, both to Colorado and New Mexico. He graduated from the law school at the University of New Mexico, took a job shortly thereafter with the state of New Mexico, and made his way to the state engineer's office to address water issues. And I've always been impressed by DL's real interest in sort of the social justice issues of water management and water allocation. And DL, you've been with Chief Counsel since 1990, is that right?
I was Chief Counsel from 2001 till last June. For June 1st,
Okay.
I'm retired.
Oh, you're retired. Excellent.
I don't have cards yet. But
Well, you can give us the real story then this afternoon. Secondly, we'll hear from Honorable Bruce Lobel, the retired Chief Water Judge from the state of Montana. He served in that position from 1990 to 2013. His court was in Bozeman, although he presided over the statewide adjudication in Montana. He pioneered sort of the institutionalization of the water court, reviewed and incorporated several major Indian water rights settlements into the general stream adjudication. He received his BA and JD from the University of Montana, was shortly a trademark attorney in Washington, D.C., but came back and practiced law with his father in Helena for some years before he was appointed to the court. I think Judge Lobel is sort of the dictionary definition of judicial demeanor: firm but calm, positive, and often humorous. We'll third hear from John Weldon, who's a partner and shareholder in the firm of Salmon, Lewis, and Weldon in Phoenix. He graduated magna cum laude from Fresno State and went on to receive a law degree from Hastings College of the Law, University of California in San Francisco, where he was a member of the Order of the Coif. He made his way to Arizona and has participated for many years in the general stream adjudications in Arizona, along with many other water issues. One of his principal clients is the Salt River Project, which is a major purveyor of water in Arizona. And I think John is sort of the lawyer's lawyer. He's knows the law, knows the facts of the case, always creative and forceful in his presentation, either verbally or on paper. And I think very fairly, he is probably considered the dean of water law attorneys in Arizona today. And then we will hear from Clive Strong, who's the Deputy Attorney General with the state of Idaho and Chief of the Natural Resource Division of that office, an office with which he has served, I believe, almost 30 years. Clive received his bachelor's from University of Idaho along with his JD. He went on to obtain a master's of letters of law from the University of Michigan. I mentioned I had the opportunity to attend this Snake River Symposium in August, and I can say uniformly, everyone who spoke had great words for Clive's role and leadership in the Snake River adjudication. And as a result of that service, among others, he was awarded just last month the American Bar Association's Environmental, Energy, and Resources Government Attorney of the Year. So I want to congratulate Clive on that achievement. So a great panel. I'm pleased to moderate it, and we'll turn it over to D.L. Sanders for a discussion of New Mexico's adjudications.
Thank you, John. I've been doing this for so long. First of all, I want to make it clear. I was born in Detroit and moved when I was 2. My father was in the Marines. He retired to Albuquerque in 1967. where I resided until I left high school in '75, never to return to New Mexico, ended up through 7 years later, through a roundabout way, ended up back doing law school, and even more roundabout way doing water. I interviewed for the position of clerk with the general counsel, the state engineer at the time. I thought, what a great job that guy has. So I can tell you how much I appreciate ever having ascended to the position of chief counsel. We changed the name because we went from my original hire, I was the 7th lawyer in the office, to when I left, we had 22 lawyers and another staff of 50 people just dedicated to adjudications and water litigation. Congratulations on the Wind River adjudication completion. That's a big deal. I know how it feels. I did the Hamas adjudication. I got the non-Indian water rights done, the partial final decree. Our decree is not quite as impressive, all the supporting documentation. The decree itself is about 3 pages. The documentation is, we do it chronologically by documents, cross-index for every water right, so you can go to it and find every order that affects your water right, so you can interpret it. We did it by priority date, so you can go find what your priority date is in order if there's a priority call, and we did it by type of right, in case we decide to call some out and not curtail them. I didn't get my homework assignment. I kind of forgot about it, and I'm sorry. I am the worst panelist ever. I do have lots of notes about all adjudication in New Mexico, so if it's okay, I'll give you kind of an overview about the complexities that are confront not only New Mexico but every other state. We have them all. Let me tell you that in New Mexico, I've been involved in, like I said, we have 13 pending adjudications. Of them, I've been involved in 3 Indian water rights settlements. One was for the Navajo, largest tribe in New Mexico. It involved 360,000 acre-feet of water depletion and another 600,000, 20 or 640,000 total for diversion. They can only exercise certain portions of that water by getting permission from the state engineer. It's a lot of water, largely based upon the Navajo Irrigation Indian Project that has been under construction since the 1960s. Never fully built out. We did that in recognition of the Winters Doctrine, but we ignored federal rights, the Federal Reserve Rights Doctrine. We did that all in return for us helping them get a pipeline, the Navajo get a pipeline, extending from Farmington, New Mexico to Gallup. So if you look at my big map up there, if you look in the upper left-hand corner, there's a little blue streak. That's where the San Juan River is, touching on the Navajo Reservation. From that corner all the way down to I-40, which is about a quarter of the way down, is a pipeline. It's about a 40-mile pipeline. It's going to cost about $1.2 billion, of which the federal government's responsible for about $950 million. That was how we settled that case. The other case was in the Ammon adjudication involving 4 pueblos, 3 streams, all interconnected. In that case, we settled on the pueblos' water rights. There were many decisions that were entered. The pueblos' water rights are different than tribal rights as defined in New Mexico. Pueblos are different because they hold their land in fee, because they largely have resided on the very same lands they've always resided on. Therefore, they get what we call a time immemorial priority date. It's simple. For fee lands, you get a time immemorial priority date based upon the irrigation practices up until the Pueblo Claims Act was in 1898, I think. Is that right? 1932, excuse me. And in that, they resolved all the Indians' claims for malfeasance by the United States in failing to maintain their fiduciary duty to protect the Pueblos' rights. In that case, it's a very short, all 3 stream systems are very short. They've made priority calls. Rather than perpetuate the litigation, by the way, I should mention this was filed in 1966. It's the longest pending case in the federal docket in the United States. And the picture that I think that you showed, John, of that's just our one little adjudication. There's probably only about 8,000 people involved in that adjudication. Same kind of paperwork. Darcy Bushnell, who's here, could probably give you, she once told me the number of linear feet in the federal courthouse that the pleadings in that case took up. And it was about, it was significant, it was very significant. Anyway, we managed to settle that case not by going back and adjudicating things or relitigating other issues or creating new issues to litigate. After 3 failed opportunities to settle this in the 4th try, it was hit upon, why don't we build a pipeline, bring more water in, augment the existing supply, and that's what we did. So we're presently in the process of doing the groundwork for laying that pipeline. The federal government committed to pay about $200 million. The state's on the hook for about $50 million. Or $25 million, I believe. That's more accurate. And the other was a Taos Pueblo. The Taos Pueblo is a significant settlement because they have what they call the buffalo pasture, and it's sacred to them. And the way it was irrigated was through sub-irrigation. But as a result of all the pumping in the area, there's a very limited amount of surface supply. And that was all being used by the irrigators and diffused across a much greater area. The buffalo pastures was no longer being sub-irrigated and was drying out. So this settlement involved digging 1,000-foot wells, moving wells away from the Pueblo, and allowing water to come in and run through ditches to recharge the aquifer, thereby bringing the sub-irrigation back to the buffalo pasture. That was resolved, it's worked, I believe, and we settled those claims. As to why adjudications take so long, let's see. Most states in the West have very similar objectives. Their statutes are very similar in what they attempt to do. New Mexico is based upon a model code called the Bean Code. Morris Bean was an engineer and lawyer who served in both capacities for the U.S. Reclamation Service at the turn of the century. When reclamation came in, they were trying to figure out, if we're going to build projects, there has to be a supply of water. To know whether there's a supply of water, we need to know what the water rights are and what the demand is. No state really had a good process for that other than Colorado. So he developed this code that New Mexico largely adopted, as did Oklahoma, and North Dakota, and South Dakota. And what it did is it kind of took the tension between, do you do the engineering and have the engineers regulate water, or do you have the lawyers and the judicial system regulate water? And they kind of combined both of those. So you have like state engineers, who are the technical people, and AGs like myself, who was litigating over the water rights. It's kind of it works, but it's aggressive. And what we did is we improved upon, I'll turn to what the New Mexico Supreme Court said. The New Mexico Supreme Court, in looking at our process, said, and I think it's kind of true, all the states in the West all kind of vie for my way is better than your way. And adjudications, we'd like a lot to be true, one state would like that to be true. So the New Mexico Supreme Court characterized New Mexico's adjudication process this way. Colorado was the leader in statutory adjudications 25 years before New Mexico began its adjudications. In light of Colorado's experience, New Mexico undertook a more thorough job. Our scheme is much more logical. But then it went on to say, and no words were ever more prophetic, this is 1932, whether New Mexico's scheme is so ambitious as to be impractical remains to be determined. So you figure most of our adjudications were filed in the 60s and early 70s, and we're still plodding along. Some of them, we used to not be able to see any light at the end of the tunnel. Now we see a pinpoint. We know there's an end, and we're getting there. Which the name of my talk today then kind of leads me into that is the birth of the New Mexico Leviathan. And the reason for that is because these are creatures that are poorly understood. Nobody knows what they look like. We've all been grappling with them. Everyone looks different, and we're trying to standardize them, and I think over the years, we're getting there. The New Mexico legislature, I think, would refer to them as 50 years a budget black hole. For my 24 years, I did a lot of legislative stuff, almost exclusively for the agency. I had to testify year after year about why these were never getting done, and it really comes down to a function of money and legislative will. If you'll give us the money, we'll get them done. And I think that's been true. I think the Snake River adjudication, $93.9 million to get that done over 27 years. That's close to what we've been spending in New Mexico. Over the 15 years for which I oversaw adjudications, On average, I'd say our budget was about $2.8 million. Had 22 lawyers, 50 staff, and that works out to be approximately $42 million. So we're kind of on that pace, I think. Anyway, it takes forever to get these done. Why does it take so long? Because issues involving tribes and pueblos are controversial. If you're a tribe, you were here first, you believe that you're entitled to water, and you want to have that, you want a court to confirm that. The non-Indians, like, well, if they were here first, they're not using that much water. We're afraid of what will happen if they get that much water, and we will fight that to the bitter end. So you have to go through the process of winnowing out some of these issues and getting them decided. So there's some baseline that we all know we're operating about. I don't know if courts do it on purpose or not. I've been a hearing officer. I know I didn't do it on purpose. It's just the way it works out. The decisions often come out, including the ones I've worked on, are so unclear that it causes everybody thinks they won something, but nobody's really sure whether they get to keep it. So that's when you sit down and talk, because it's the downside of what that decision that might mean that gets you to the table. The non-Indians also, they're not eager to settle, because, especially in periods of drought, because why do we do adjudications? To order priorities, to know who has what amount of water, so we can shut you off during times of drought so seniors can get their water. If you are a potential junior, you have no incentive to get these adjudications done if you can avoid it. And I think that's a fact, and I think it's been proven. I mentioned funding levels. In New Mexico, our problem is, unlike the Wind River or the Snake, we've not had singular focus on one adjudication. We have 13 adjudications, all going in various forms. I'll explain more about that. Also, the sheer numbers. We are one of the first states to put together a computerized database of all of our defendants. It's our working litigation database. It's called RATS. Somebody thought it was funny to create an acronym for that. It's WRATS. And that's our proprietary, non-discoverable litigation database. At any given day, we have 70,000 defendants on that are active. That's a lot of paper to keep track of. So let's go with this real quickly. I'll give you an overview of what's going on in the state of New Mexico. Up here, I mentioned the San Juan River, the Navajo settlement, filed in 1968. Why was it filed? It was filed because the San Juan Chama project was under construction. San Juan Chama project brings water in from Colorado through a series of tunnels into New Mexico and dumps it into the Rio Grande drainage. So that needed to be done to know what our claim is, because our share, our San Juan Chama water that comes into this tunnel comes out of our share of the Colorado River. We had to have our rights quantified to make sure we had sufficient water to bring in. Also, that case was significant. Filed 1968, decided 1972, state court, under McCarran, state court jurisdiction to adjudicate Indian water rights. Although I will say this, in trying to get the Navajo settlement done, just last year, 2 years ago, one of the lawyers representing the largest opposition force to the Navajo settlement argued that this untested and so-called reserved rights doctrine was deserving of consideration by the New Mexico Supreme Court, which of course has already acknowledged its existence. So, but when you talk about never making progress on these things, there's a perfect example of why. I mean, somebody new walks in the door and says, "Oh, I've never heard of it. It must not be a well-tested doctrine." So we had to litigate that, and it's pending now before the Court of Appeals. They lost, but it's still pending before them. We have 7 adjudications that also involve the San Juan Chama project, filed between 1966 and 1983. In the middle part, in the little dense part up there of the middle third of that map, if you can see it, we have 7 adjudications, basically. All those are tributaries to the Rio Grande. They were filed because of all the acequias, which are among the oldest water rights in the state behind the Pueblos. Some of these acequias, one acequia in particular on the Chama River, was actually litigated the difference between what we recognize as the prior date of 1600 and what they claimed the priority date to be 1598. Now, think about that. There are only Spanish and Indian native speakers. So in order to go back and litigate that case, you have to go through all the Spanish archives. We go through the archdiocese records to go through and try to establish whether people were there and we can identify them. There are, I'm surprised, shockingly, there's records of all of this. So that adds to a layer of complexity to our adjudications other states have to deal with. I mean, I listen to people like, yeah, our prior dates go back to 1950. It's like, 1850. You know how hard it is to go really make a credible case as to a priority date of 1602? That's tough, especially in Spanish, when you have to hire historians, you have to hire Spanish legal experts in order to determine what the nature of the law was, to know what they had. Fascinating stuff. All right, so those are going on. I will mention the Santa Fe, where I'm from, Santa Fe. Our adjudication there is what I call is really a foo bar. Most of you with military backgrounds know what that means. It's something up beyond all recognition. It's been sitting dormant for so long, nobody really understands what happened and what we're going to do with it. So in summary, I would say that our adjudications, as far as I've gotten anyway, is the challenge of dealing with these ancient priority dates, quantifying the historic water rights, means pre-1868 water rights of pueblos, before they were ever, for what their actual use was, trying to figure out what that amount of water was. That means you have to hire archaeologists, you have to find agricultural experts who can talk about the nature of agriculture at that time, what kind of crops could be grown, what kind of water demand there would be. It's fantastically complex. These aren't excuses, these are just facts for why ours takes so long. On the Pecos, I'll also mention real quick, the longest pending adjudication in New Mexico was filed in 1956. So we're closing in on the 60th year, and I can guarantee you there will be a 70th year. And it's disappointing, but it's complex. It's an area that has 3 different kinds of water supply: a surface water supply, a shallow aquifer, and then an artesian aquifer. And they are all conjunctively managed. And the Pecos River Compact, which we lost against Texas, requires us to conjunctively manage those. So in 1956, we undertook to consolidate all the surface water rights that had been previously adjudicated and consolidate them with all the groundwater rights. And we almost got most of it done until there was a decision by the Supreme Court that undid a large portion of it. And that was a case called Allman. And Allman, the Supreme Court ruled that when you had one stream adjudication consolidated with another, then they both had to rely on the same fundamental law. And on one case, in one of the stream systems that was consolidated in, there was a decision called Templeton. And in that case, it said, if you went from surface water to groundwater, you get to take your priority, your surface water right, to your groundwater right, provided you can prove it's the same source. So all these groundwater rights that have been adjudicated at this point, once consolidated, the Supreme Court said, you have to apply that same theory to all those other water rights if they want. So hundreds, if not thousands of people came in and said, well, we want to relate our water right back too. So that has become a nightmare case for New Mexico because nobody wanted to do it. It was done. We've left it sitting there, and I don't know what the future of that is. And I'm out of time, and I almost made it. Thank you.
Thank you, DL. We'll now hear from Judge Lobel about Montana's adjudication.
Thank you very much. It's a pleasure to be here in Wyoming. So this is what a room full of Wyoming water witches and wizards look like, huh? Okay. I want to thank you for inviting me to this conference. This is a wonderful hotel. When I was checking in, I ran into a fellow who said that he was checking out, he says, this is the lap of luxury. He said the towels are so soft and luxurious and fluffy that he had trouble getting his suitcase closed. So I wonder if any of you will have any trouble with that. Montana began its water adjudication in 1979, and the legislature carved out the jurisdiction out of our district courts, our general jurisdiction courts, and created a special court, a really special court called the Water Court, staffed it with wonderful people,
found a water judge who was just spectacular, and then proceeded on. And unfortunately, that chief water judge died, and I was appointed in 1990. And the general jurisdiction, we started out with about six or seven FTEs. We now have 23 and a half FTEs, 13 and a half water masters, and they are special masters under Rule 53 of the Montana's Federal Reserve Rules of Procedure. We have in our audience, so we have 3 water masters and a law clerk from Montana. Once you guys raise your hands, this is where the expertise in the Montana Water Court resides. These are the people that do the work. I used to say that the water judges come down and shoot the wounded after the masters do the work, and one of our staff said, no, you heal the wounded. So they do the work that our general jurisdiction judges used to do in Montana for 100 years. They do the meet with the hold the hearings, meet with the water users all the time, and provide master's reports. And then when they finish their master's reports, then the water judges come in and review the master's reports and can modify them or reject them or that sort of thing, just pretty much like a Rule 53 special master. When the legislature started this adjudication, it created the largest lawsuit and the most complex lawsuit in Montana's history. It was about, we have about 70,000, somewhere around that, litigants. We have 219,000 claims. It's across the entire state of Montana. And we have a mission statement. And our mission statement at the Water Court, every organization has a mission statement. So this is the mission statement of the Montana Water Court. We're bringing peace and harmony to the water users of Montana. And you can see that building up there is the Life of Montana building. It's appropriately called that because that's where the Water Court is. You can see there's a rainbow. That rainbow ends right on the Water Court portion of that building. That's where the knowledge resides of all the water rights in Montana. So we're doing well, I think. Why did we start the adjudication, some people ask. If you might remember what happened in 1972, 73, some of you were around then. What do you remember as being a really big thing in this country in 72, 73? I can't hear you up here. Coal. Yeah, there we go. Energy development. There were lines for gas. So in 1970, 72, up through about 1979, people started casting covetous eyes at the coal and water in eastern Montana. We had energy companies, Texaco, Mobil, Tenneco, any kinds of companies that were going to come up and develop the coal reserves, take that water, and produce electricity or gasification. There was a federal study that said 70 or 80 points in Montana would be just terrific for a coal gasification plant. And each of those coal gasification plants would take about 10 to 15,000 acre feet. So that got the legislature a little nervous about all that. There was even companies up there that were talking about mixing coal and water and slurrying it down to Texas for use in coal gasification plants or coal-fired generating plants down there. So the Montana legislature put a moratorium. That's the state of Montana. You can't really see it, but the Yellowstone River, for most of the people in Wyoming, probably know where that is. The Montana legislature put a moratorium on water rights being diverted from any more water rights from the Yellowstone River. They created a legislative interim committee to discuss what to do. And then what happened in 1975? Those pesky federal lawyers showed up. And there's one back there I can see from the solicitor's office in Billings. The federal government and the Northern Cheyenne tribe filed 3 lawsuits in Montana over the water rights in the, let's see, I got to get all of them right. The regarding asserting the claims of Northern Cheyenne and the Crow tribes on the Tongue, the Big Horn, the Little Big Horn rivers, Rosebud Creek, and other sources. U.S. Marshals started serving federal summons and complaints to water users on those rivers. That got everybody's attention. The 1970 and 1978, the Legislative Interim Committee said we need to have a special court and we need to have a mandatory claim filing process and get the adjudication of water rights done so we know how many water rights there are, how much water right can be diverted for other purposes. Then, when the legislature began in 1979, the feds filed 4 more lawsuits regarding asserting claims on behalf of the tribes of the Fort Peck, the Fort Belknap, the Rocky Boy, and Blackfeet reservations. Again, federal marshals were serving complaints up and down those rivers. And if you might remember, John Thorson was talking about a race to the courthouse. That was the theory at that time, was whoever got their foot in the courthouse, that's the jurisdiction that would take over the adjudication of water rights. So they eventually, shortly after those last 4 water lawsuits were filed, the Montana Supreme Court passed Senate Bill 76. They created the statewide adjudication. They said everyone that had a water right that existed prior to July 1, 1973 had to file that claim or it would be abandoned and forfeited, with some minor exceptions for stock and domestic uses. That included reserved water rights. The federal government and the tribes took that issue and went to the Supreme Court of the United States. The Supreme Court said Montana does have jurisdiction over reserved water rights as long as there's a general jurisdiction. But they did not, as long as there is a general water rights adjudication is what I meant to say. As long as that is going on, but they did not dismiss those 7 lawsuits, they merely stayed them, and they can be reactivated if circumstances change. So all of those lawsuits are kind of sitting out there, although nobody can find them. I once looked for them, and there's someplace, you know, the Raiders of the Lost Ark. Have you ever seen, you remember the last part of that? Or where they hid everything in that government warehouse? That's probably where those lawsuits are. Nobody knows where they are, which is good. Claims that were not filed by a date, which eventually became April 30, 1982, were forfeited. And several were. Many people did not file their water rights. The way we operated it, there are 85 hydrologic basins in Montana. Every basin we treat as a kind of a separate adjudication, and then we move it forward and merge it with the rest of them. The Department of Natural Resources and Conservation has a claim examination rule manual and rules from the Montana Supreme Court. They examine every claim that came to them. They do it in the context of one basin. The DNRC gave me a special manual for this claim examination manual, and this is what they gave me early in my career. That's the manual that they use to examine claims in Montana, and if they find that there's a problem with an issue of factual or legal rights or legal issues, then they will put an issue remark on the claim. And then those issue remarks often form the objection process that comes along. So we then go back to our map. The water court will issue a decree of all the water rights in a particular basin. We'll give notice to all the water users. We'll publish notice. And that starts the process for an objections. They get 180 days, which could be extended, and objections can be filed. And once all the objections come in, counter objections, then those wonderful, bright, young water masters will go out and solve all those problems, and the adjudication will be over. Now, what do we do about federal and reserve and Indian reserve water rights? The Montana legislature looked at Nevada, Wyoming, and said, why don't we do it differently? They created a Reserve Water Rights Compact Commission composed of 9 people, 4 appointed by the legislature, 4 appointed by the governor, 1 appointed by the attorney general, gave them a staff and said, go out there and negotiate those reserve water rights. Now, in Montana, we have 7 major Indian reservations. We have 2 significant national parks. We have a state filled with national forest lands. We have BLM lands. We have federal reserve or refuge, wildlife refuges. If we wanted to litigate all of those issues that come out of those issues, out of all those reservations, we could be at this for a very long period of time. So they said, let's negotiate it. And the Reserve Water Right Compact Commission, Barb Cousins was a member of that. Raise your hand, Barb. Anybody wants to know about the Reserve Water Rights Compact Commission, she was the staff attorney for them for how many years? 10 years. Did good work. They negotiated a lot of compacts. When those compacts are completed, they have to go to the Montana legislature and be approved. They have to be approved by the federal agencies. If it's a tribe, it has to be approved by the tribe, and then it has to go to Congress. And remarkably enough, after those tribal compacts go to Congress, they come back to the water court to be reviewed. And the water court then creates a compact, sends them out, gives notice. When we did the National Park Service, we sent out 23 notices. We'll have hearings on them, and remarkably enough, the chief water judge can apparently overturn Congress if he wants to do so. But so far, we've never done that. And I have personally reviewed and approved 9 compacts involving 3 Indian reservations, 2 national parks, a certain amount of BLM lands, all the national forest lands, and some assorted wildlife refuges. And the most interesting thing is that we have 1 reservation up in the northwest part of the state that is coming up to the deadline of 2015 to get their compact through the legislature. They received the compact in 2013, or they entered into a compact. They took it to the legislature in 2013. The legislature did not approve it. They're now coming back in 2015. If they don't approve it in 2015, they file their water right claims, and 10 to 15,000 of them, and will be in a situation similar to what you were in Wyoming. And I just want to close with a kind of a going away present. In Montana, we now adjudicate water rights in a civilized manner. We didn't always do so. We use shovels and Winchesters. And one of the first murders in Montana that took place was over water. A fellow went to his diversion ditch and found somebody stealing his water. He shot him, took the lifeless body, stuffed it into the stream, and used it as a diversion dam to divert water into his irrigation ditch. And I want to tell you, we don't do that anymore. We first require a Corps of Engineers dredge and fill permit. So, thank you very much.
Thank you, Judge Lobel. We'll hear now about Arizona from John Weldon.
Wrong way. There we go. Good afternoon. I'm John Weldon. I'm from Phoenix, Arizona. I'm going to show you a little map of Arizona right here that helps explain what I'm going to talk about. We have 2 adjudications pending in Arizona. One is for the Gila River general adjudication. It is the blue lines that are on the bottom half of the map, and it encompasses most of the water in Arizona that's not Colorado River water. The second adjudication is the blue line that's in the upper portion of the map that drains into the Colorado River. It's the Little Colorado River system. Now, the fact that these lines on this map are blue doesn't mean anything because most of those are really brown. There's no water or not much water in Arizona. As I said, we've got 2 general stream adjudications going. One on the Gila River system. It was commenced by the Salt River Project, the client that I represent, in 1974, and at that time it did not include the entire Gila Basin. It just included the Salt River and a portion of the Verde River. That case was filed in 1974, and it was kind of dormant until 1978 while the parties were trying to negotiate resolution of some Indian water claims on the Salt River watershed. The Salt River watershed is about 13,000 square miles. It has 8 Indian reservations on it, most of whom are relatively early priorities, and they're almost all, well, they are all upstream of the Phoenix metropolitan area, except for the Gila River Indian Reservation, which is immediately downstream of the Phoenix metropolitan area. Those negotiations were not successful, and so in 1978, the Salt River Project and the state served the petition on the United States, the Indian tribes that were in that geographic area, as well as the other state parties that were potential claimants. That resulted in this race to the courthouse that you heard described a moment ago. Several of the tribes filed actions in the United States District Court in Arizona to adjudicate their own rights, not in the context of a general stream adjudication, but just to adjudicate their own rights. The Navajo Nation filed a similar proceeding in the Little Colorado, relating to the Little Colorado. From 1978 to 1985, those cases were the subject of litigation in the Federal District Court in Arizona, the Ninth Circuit, and eventually culminated in the Arizona v. San Carlos decision by the United States Supreme Court in 1983, which affirmed the existence of state court jurisdiction to adjudicate federal reserved water rights in our proceeding. That 1983 opinion left one dangling participle of federal or state court jurisdiction that was a matter of state law pending, and so from 1983 to 1985, that issue was litigated in state court and eventually resulted in a decision by the Arizona Supreme Court, which again affirmed the jurisdiction of the state court to proceed with these adjudications. The cases that were filed in district court are still pending, although most of them have been dismissed as part of some settlements, which I'll talk about in a moment. They're not lost, though. The 2 that are pending are not lost, because every 6 months we have to file a status report with the court describing what's going on with the state court adjudications, because if progress isn't being made on whatever might be described as a sufficient basis, the court can reassume jurisdiction over those cases. So far, that has not happened. The Little Colorado River adjudication was commenced in 1978 by Phelps Dodge Corporation, which is now Freeport McMoran Copper and Gold, Inc. It has 14,000 claimants and about 14,000 claims asserted by 5,000 individuals. The Gila adjudication has about 82,000 separate statements of claim filed by 30,000 claimants. Now, just to put this in a little context for you, the average annual supply of the Gila River system is about 1.3 million acre-feet of water. The Salt River Project, which I represent, uses about 900,000 acre-feet of that supply every year. And so that leaves a little bit for the remainder of the state, and that's why we have all these competing claims. The Little Colorado has an annual supply, an average annual supply that reaches the Colorado River of about 160,000 acre-feet. And so you can see that we're fighting, there's a lot of people fighting over not much water. What water is subject to the adjudication? Arizona has a bifurcated system, which is archaic. Our Supreme Court has recognized that, but it also said that it's too late to change the process at this stage of the game. Surface water is appropriable under Arizona law. Percolating groundwater is not. And so it is not subject to the appropriation doctrine, but is rather governed by the reasonable use doctrine. There is a sort of an intermediate description of water called subflow, which is unique to Arizona. It's underground water that's closely aligned with a flowing stream, and it is appropriable. And I'll talk a little bit more about that in a moment. And the adjudication statute provides that it's all water that's appropriable under state law that is subject to adjudication, plus all water that is subject to claims based upon federal law, whatever that might be. And so the United States has asserted claims, and as well as tribes, to not only surface water, but percolating groundwater. And in 1999, the Arizona Supreme Court concluded that, in fact, under certain circumstances, a Federal Reserve right to groundwater, percolating groundwater, does exist in Arizona. That doesn't extend to state law-based claimants. And more importantly, the Supreme Court also concluded in that same decision that these Federal Reserved rights are entitled to greater protection from pumping percolating groundwater than state law-based surface water rights. And so you have found a collaboration between state law surface water users and some of the federal claimants, because we can rely upon this greater protection that's afforded Federal Reserve water rights to preserve our own supplies when those supplies would not be protected as a matter of state law. Why the adjudications? Well, Arizona went through a tremendous growth period following World War II, and most of that growth occurred in the Phoenix metropolitan area, which is reliant on surface water from the Salt and Verde River. And there had been no administration, practically speaking, of any surface water supplies in the state. There was a federal court decree entered in the Upper Gila, and it extends into New Mexico a little ways in 1935, and that's pending in federal court, and that decree is being administered by the federal court. But aside from that decree, there really wasn't any administration of surface water supplies in Arizona, and so you found people developing surface water uses upstream of the Phoenix metropolitan area, and it was having obviously an impact on downstream flows. And so the early surface water users were concerned about that, and so that was one aspect of why we're involved in these adjudications. The other aspect is that Arizona has 22 Native American tribes with 21 reservations, and almost all of those are upstream on these watersheds. Only 4 were quantified in Arizona v. California, and so it left the remainder with unquantified claims with relatively early priority dates, and also most of them didn't use much water. The water development on these reservations was pretty much undeveloped, and so they were encouraged, the reservations in the United States were encouraged by the holding in Arizona v. California, and so they were getting more active in trying to figure out ways to put water to use on their reservations that had been neglected for all of these years. And so the downstream water users were concerned about that and the effect that that might have on their own water supplies. And uncertainty is not good for municipal development. And so that was another reason why these adjudications were initiated, to try to resolve those claims. There are also a number of other federal claims in Arizona. The United States Forest Service has lots of land, or wilderness areas, and there are also Department of Defense facilities. Finally, on the Salt River watershed, the Salt River Project was concerned about the fact that there were a huge number of groundwater wells that were being drilled in the Verde Valley. Those wells increased over about a 35-year period from a few hundred to more than 6,000. And that is a major concern for the downstream users in the Phoenix metropolitan area. And so that played a significant role in why these adjudications were filed. This is just a little map that shows the pink are Indian reservations in Arizona. It gives you up in the right-hand corner is the Navajo Reservation, which also includes the Hopi Reservation. And you can see that there is a lot of land in Arizona that is encompassed within these reservations and on these watersheds that are under adjudication. The major parties to the adjudications are the Salt River Project, which initiated the Gila River adjudication, Phelps Dodge, which is now Freeport McMoran. It's a big claimant in the was a big claimant in Little Colorado. It's not so much anymore, but it is now a big claimant in the Gila adjudication. The United States, in its own right and as trustee for Indian tribes, is a huge player in these cases, as are each of the individual Indian tribes, all of whom have filed their own claims. The municipalities, irrigation districts, and other tributary water users, as you might expect, are interested in the outcome of these cases and play a significant role in the litigation. The adjudication process is very similar to what you see in most of the western states. You file a petition, claimants, it's served on potential claimants, they file claims, those claims are filed with a court. Here in Arizona, the Arizona Department of Water Resources acts as a technical advisor to the adjudication court. It does not assert claims on behalf of the state. It's the administrative agency that helps the court sort through all of these various competing claims. The state is represented by the Attorney General's office, and it represents the State Land Department, which has about between 9 and 10 million acres of state land in the state, as well as all of the other state agencies that claim water rights. And so we have a little different situation than some of the other western states with respect to the role the Department of Water Resources plays in these proceedings. The department just prepares a hydrographic survey report. It describes water uses by watershed file reports. The claimants file objections to those watershed file reports. Those objections are litigated before the special master. He or she renders a report. That objections can be filed to that report, and they're heard by the Superior Court handling the case, and then that Superior Court judge decides those objections, and eventually the process is supposed to end up where you have all ended up in Wyoming in a decree, but unfortunately we are a long ways from the decree stage. The current status of the case, the Arizona v. San Carlos Apache tribe confirmed jurisdiction for these western cases, and so that was a major landmark in our cases. Since that time, there have been 11 other decisions primarily in the Gila adjudication rendered by the Arizona Supreme Court on various legal issues that have been raised during the early stages of the proceedings. The last of those decisions so far was a decision I say a year and a half or so ago, 2 years ago, that rejected the claim by the Arizona State Land Department that it had a federal reserved water right for all of the state land that was given to the state when Arizona became a state by the United States. That was a big decision because, as I said, there's between 9 and 10 million acres of state land in Arizona, and if that claim had been recognized with the early priorities which they were claiming for those lands, that coupled with the early priorities for the various Indian reservations in the state, there wouldn't have been water for anybody else. Because of our bifurcated system of water law in Arizona, we've spent 26 years litigating this definition of subflow in the context of the San Pedro watershed. That issue has been to the Arizona Supreme Court twice. We've had, I can't imagine how many hearings we've had before the Superior Court on where the line is along the edge of the San Pedro River that constitutes a subflow zone line. This past April, the Department of Water Resources issued a report following a big court hearing on where the line should be drawn. Objections to that report are due on October 1st. It's a improved report. It's close to the mark. We're not quite happy where the line is, but it's close, and we'll see what the court does with the objections that are filed to that report on October 1st. In the meantime, not one state law-based water right has been adjudicated. That's not to say that we haven't made progress, because this is sort of a schizophrenic proceeding. We have 9 congressionally approved Indian water rights settlements in the state. 8 are fully completed and in effect and enforceable. One is now pending before the court, both adjudications, because the White Mountain Apache Reservation is on both watersheds, the Little Colorado and the Gila, and so it's pending for approval before the court. Objections to the report or to the settlement were supposed to be filed by September the 8th, this past Monday. So far, I've only seen one objection, and it doesn't appear to be a substantive problem. So there's always a little bit of a lag between the filing of objections and when you find out that they have been filed. So we'll see. Hopefully, there won't be many objections to it, and that settlement will be completed before the end of the year. There are also a couple of ongoing negotiations that are making progress, but we are hampered, I think, as a practical matter, in the completion of those by the retirement of Arizona's junior Senator John Kyle, who led the charge in the United States Senate, not only for Arizona settlements, but for settlements throughout the West. And with his departure, we are lacking an individual in the Senate or in the House who seems to be willing to pick up the time to advance these settlements. The Gila adjudication, because of the involvement in the settlement of the Indian water rights cases, is probably about a third of the way done as a practical matter, despite the fact that all of these state law-based rights are yet to be adjudicated. The Little Colorado River adjudication is probably only about 5% resolved, because that 5% relates to a settlement with the Zuni Indian tribe for Zuni Heaven Reservation, which is in northeastern Arizona. Finally and last is just a little slide that shows where these reservations are that have been resolved, and there is a list of all of the various congressional acts that approve these settlements. So my time is up, and I'm going to sit down. Thank you very much.
Thank you, John. And I understand that these slides will be on the website for the conference, so if you want to see them in more detail. And now to a little more positive story from Idaho, Clive Strong.
Yeah, let me see. Oops. There we go. Well, it's a pleasure to be here this afternoon, and particularly to be able to come and listen to your story. I've spent a lot of years reading about the Wind River, or the Big Horn adjudication. I know a lot of the participants in the Big Horn adjudication. I go back to the days of Jeff Fassett, so that dates me quite a ways. But in many ways, I feel kind of a part of this story because we've learned a lot from what you've done, and I'm going to talk a little bit about that today. But before I do that, it seems like we spend a lot of time apologizing for the length of time it takes to complete these adjudications. And I've been as much guilty of that as anyone else. But last week, on August 25th, when Justice Scalia came to Boise, he put our adjudication in context. And what he did is he looked at, and before I go to that, what I have here is a map of the Snake River Basin adjudication. In the darker green area is the Snake River Basin itself. It's 85% of the land mass of the state of Idaho. Only the northern panhandle and the very far corner are outside of that area. So by and large, with the Snake River Basin adjudication, we have completed, oops, going the wrong way again, completed most of the adjudication within the state of Idaho. And on this slide, I have kind of the critical facts. I don't intend to spend a lot of time talking about those critical facts. I'll leave them for you to look at, and they will be in your materials as well. But the one I want to focus on first is the number of claims that were decreed in the adjudication. And we decreed just over 158,000 water rights in the Snake River Basin adjudication. That was done in a 27-year period. And what Justice Scalia did was he took that 27-year period, calculated the number of days and the number of hours involved in that, and converted our claims into a time process. And it turned out that we were adjudicating one water right every 90 minutes for 24/7 for 27 years. And when you put it in that context, that's a lot of work. It's a lot of work that's been moving through the adjudication. I tried to do the same thing for your adjudication, but your process is a bit different than ours, and the only thing I've been able to figure out is that you have about 25,000 claimants in your adjudication. And if you convert that 25,000 claimants, you assume each one of them and their water rights are adjudicated, and you convert your 37-year period, what you'd find is you are adjudicating about 2 claims every day. The claims for each claimant, all of their claims, 2 of them in each day. And that would be again on a 24/7 basis. So it's not something to apologize for, it's something to recognize that the magnitude of this task is so large that it is necessarily going to take time. What you really have to evaluate is how productive you've been with that time. And so that's where I'd like to focus my remarks today, is why was Idaho successful in completing this adjudication in 27 years versus what's going on in the other states? And my first remark would be that the thing that we did best is we stole liberally from the other states. We started later than everyone else, and one of the first things we stole was we looked at what was going on in the Big Horn adjudication. And at that point in time, you'd been through your litigation phase, and probably something most of you don't know in this room is that the Fort Hall Indian Reservation, upon which the Shoshone Bannocks reside, was created under the Fort Bridger Treaty, the same one that you'd been litigating. So we had the benefit of the law that had been established, and we looked at that law and we made a risk assessment. That's what we do as attorneys, and our risk assessment was that that decision was going to stand, and it wouldn't make sense for us to simply litigate the same issues over again, expecting a different outcome. The other thing that we knew is that the practical arrogable acreage standard would be applied, and so that was another thing we looked at. Likewise, the Shoshone Bannock tribes had the same opportunity to examine that, the outcome in the Big Horn adjudication. And to their credit, they looked at it and they came to the same conclusion we did. And in a virtually unique situation, they approached the state of Idaho before we commenced the adjudication and requested an opportunity to negotiate with the state. And our legislature passed a resolution putting the adjudication on hold to give us an opportunity to begin the negotiation process with the Shoshone Bannock tribes. And I'm pleased to report we started those negotiations on September 1st, 1984. And we completed a 1-page term sheet on September 1, 1989. 5 years it took us to get to that 1-page term sheet, which outlined the water sources and the major principles that were going to go into our agreement. And within 6 months, we had completed the 1994 Hall Indian Water Right Agreement and had it approved by Congress by the end of that calendar year. So what I'm here to say is that there is opportunities if we learn from our past experiences. And we appreciate the roadmap that you laid out for us. We recognize not only in that negotiation process that it wasn't just about adjudication of water rights, but there was a long-term relationship that was being developed. And so in our settlement with the Shoshone Bannock tribes, we included provisions that deal with the transfer of water rights, that deal with the administration of water rights, and provide a water development fund for the tribes so that they have wet water that they can put to actual beneficial use. But more importantly, we included in that settlement agreement an intergovernmental board. And that intergovernmental board meets on an annual basis, more frequently if necessary, and we meet to discuss implementation issues associated with the 1994 Hall Indian Water Right Agreement. And we have already had an opportunity to test that process a couple of times, because when we put together the agreement, there were a couple areas that we couldn't finally resolve because we didn't know the extent of the water rights. So what we did was we put a placeholder in there and then came back and negotiated those provisions once the state water rights were adjudicated. And we went through a process. Ron Bilstein in the room knows well about that process, but we went through a process and developed some solutions to water supply problems on the Blackfoot River, and we're currently working on some issues with regard to the Bannock Creek Basin. But really, we couldn't have got where we were without the benefit of having the law well established, which you folks provided for us. That experience of going forward with that, in putting together that agreement, we also worked with the tribe to develop a process for implementation of the agreement. And we stole liberally from Montana in providing in our adjudication code for a provision for approval of these agreements. And that process has worked well for us. We had 3 Indian Reserve water rights settlements that we've concluded in the Snake River Basin adjudication, besides the Shoshone Bannock. We concluded the 2004 Snake River Water Rights Agreement with the Nez Perce tribe. Quite a different settlement process than what we experienced here. In that situation, we were dealing with the Stevens Treaty tribe that had significant in-stream flow claims. And so in that instance, we had to plow new ground, and it took us about 10 years to complete that negotiation, but we ultimately worked out a solution in which the state created minimum stream flows that jointly with the tribe to protect in-stream flows in the Salmon and Clearwater Basin. And at the same time, we began to recognize the evolving issues of the Endangered Species Act. And so in that agreement, we addressed the application of the Endangered Species Act within the context of the adjudication and the administration of water rights. So it's an agreement I would commend you to look at as kind of a wave of the future as we have to deal with some of these new issues that are coming forward. And then we had a third settlement with the Shoshone Paiute tribes that involved a cross-border issue. Half the reservation is in Nevada and half is in Idaho. Fortunately for us, the Idaho portion is the downstream portion, and it was a relatively easy settlement for us to get through. But without being able to have resolved those 3 settlements with these negotiated resolutions, we would not be where we're at today. You might be interested in what the outcome of the Shoshone Bannock settlement was. I think it's kind of interesting when I compare the numbers I was hearing today. The tribe was awarded 581,000 acre-feet of water. 500,000, 581,000 acre-feet of water. So outcomes are relatively similar, but the cost of reaching that resolution was much less. You heard some discussions about the role of the director as a technical expert. Again, we liberally stole from Arizona on that one. We encountered a situation where it was difficult for the Department of Water Resources to engage or interact with the water users. It resulted in some significant litigation and almost the closure of the Snake River Basin adjudication. But reasonable minds came together and we resolved a solution whereby the Department of Water Resources is a technical expert available to all parties. And not only did we do that, but we also included a very substantial dispute resolution process. And as you've heard people talk before, the court is the last place you want to be with most of these issues. Typically with water right issues, the easiest way to solve them is if you work cooperatively together. And by making the department an independent expert, the department was then able to implement this process whereby it would issue preliminary director's reports so every water user would get an opportunity to see what the proposed recommendation of the water right would be. They would then meet with each water user within the basin to go over those issues and try to resolve those issues as best they could. What we found towards the end of the adjudication is that, and this is not a precise number, but we believe more than 95% of the claims were resolved without the need of litigation. And although you see 43-some thousand subcases, that's a small part that were also resolved through the negotiation process. The other thing that I think made our adjudication successful is rather than following a staged process, we did parallel processes. We had the state claim processes moving at the same time as we were doing the Federal Reserve water right negotiations. And by doing that, we were able to maximize our resources. Another area that I think made a huge difference for us is that in our adjudication, unlike Arizona, we did not have the issue of subflow. In Idaho, we treat groundwater rights and under the prior appropriation doctrine just like surface water rights. And so rather than having a jurisdictional fight over whether those rights are in the adjudication, everyone was required to file a claim in the adjudication. But we didn't attempt to resolve the administration issues, i.e. how far does priority of right extend into an aquifer for curtailment. We have an aquifer that extends 11,000 square miles across southern Idaho. And depending upon where you're diverting that water, your impact on the Snake River may be within days or decades or centuries. And so it's a very complicated issue that we're working through right now. But by separating that issue and getting the water rights adjudicated, we've made the resolution of that issue much simpler. Not simple, but simpler. We've been through 3 different cases. I have those listed on my handout materials that you can obtain on the website. And I think we're getting close to getting those resolved. And then 2 last points I would make. You've heard about the technology. That was essential in our adjudication. Can't underestimate the value of the technology. We used a lot of infrared technology to identify irrigated acres. We could do evapotranspiration to determine the amount of consumptive use that was occurring on those particular properties. And when a water claimant had a dispute about how the right was being recommended, you could pull out the picture and show them what you were doing. And that made all the difference in the world. And then finally, we had a basin-wide process, so we needed to have a way to establish law of the case. And so what we did is we developed a basin-wide issue process in which we would identify up front issues that we thought would have impact across the entire adjudication, and then we would expedite the review of those cases. Within a 10-year period, the Idaho Supreme Court, we litigated from the district court through the Idaho Supreme Court 23 different cases that had basin-wide implications. So it was a huge effort of cooperation with the judiciary, but it certainly made the completion of the adjudication much simpler. So with those remarks, I'll be happy to sit and answer questions as we go forward. Thank you.
Thank you, Clive, and thank you, panelists. Excellent presentations. We have some questions we want to pose to panelists, get a dialogue going here. And Clive has addressed this somewhat, and so I ask the other 3 panelists, how did the Big Horn adjudication influence, if at all, your adjudication activity? DL, would you like to start with that?
Not really. Most of our litigation...
Is that on? Why don't you use this one, DL?
Thank you. Most of the litigation that we were involved in was contemporaneously with, and that was at the Mescalero, with the Big Horn. And so, and that was a PI case, we prevailed on that. Since then, we've settled the Navajo, we've settled with the Jicarilla. So it hadn't come up largely in those contexts because we've had other water to deal with. We haven't had to deal directly with the kind of issues that have come up in Big Horn. The one area that has given us trouble, and as far as resolving issues, was whether or not Walton rights apply to reservation lands held by Pueblos. And because they've largely not been resolved, that's where it's come up in. And it's an interesting case. I believe it's been a no decision to date on any of that. We typically end up settling, like I said, we end up going, the state, when I say we, I mean the state of New Mexico, has typically attempted to litigate some of the issues, get some baseline decisions, and then for most cases we've been able to settle our differences. And so that's largely been the product of what we've done. And so it hasn't been a big influence other than that.
Well, the Wind River case has had 2 impacts on the Arizona litigation. First, there had not been a PIA case litigated since Arizona v. California, and so in light of the difficulties we had leading up to the service of the petition in these 2 adjudications, we contemplated that we were going to have to litigate these claims against the various tribes in the United States. And so we contacted the state of Wyoming and its experts to talk to them about how they litigated the case. They didn't get a very good outcome here, but it was an opportunity for us to learn from what they did and why they did it and try to get a better outcome in Arizona. The second impact was most of the reservations in Arizona are, from a water perspective, largely undeveloped. And so if these tribes litigated their claims, they were going to get water that had not and was not being used. And from watching what happened in this case in Wind River, it appeared that there was great difficulty putting new water rights to use because there was no money available to do that. And so while the Wind River tribes got great quantities of water awarded to them from at least my perspective, they had difficulty putting that water to use. And so that was an impetus for many of the Arizona tribes to engage in settlement negotiations where they could get an assured water supply and also get the money to put those water resources to use. And so that has really been a major encouragement for the Arizona Indian water rights settlements.
Thank you. Judge Lobo, would you like to respond to that?
I think the Wyoming Big Horn adjudication is usually cited as the wrong way in Montana to adjudicate federal and Indian Reserve water rights. The detractors cite the purported high cost of that was expended to reach the result. They also cite the 4-4 Supreme Court decision in which one vote could have started the whole process all over again. And Montana, as I mentioned, has 7 major Indian reservations, national forests, multiple federal reservations, and I don't think anybody in Montana thought we could afford to do that kind of a high-risk litigation. So in the settlement process that Montana follows through the Reserve Water Rights Compact Commission, they have reached settlements that allow for subordination of tribal water rights, federal water rights to state-based rights in some fashion, in some degree. And I think that has been appreciated by most of the water users in Montana who are associated with it. And one final factor in the way Montana does it is through the settlement process is they have gone to Congress and they brought back to Montana something in excess of $500 million in infrastructure cost and other economic benefits. And that has far exceeded the amount of money we have spent on the adjudication of Montana. So by and large, we are a win-win or a economic windfall for Montana to some extent through the adjudication. So in a perverse way, the Big Horn adjudication has been a great benefit to Montana, and I thank you for doing that.
Wyoming will look at even on the current Supreme Court case concerning the Yellowstone River Compact. Clive, would you like to add anything more to what you said earlier?
I would just add one comment. We've done the same type of, the question's always, was it worth the effort? And when we've looked at it from our perspective, we spent, as you can see from the slide, $93.9 million to get to the finish line, but the federal contribution back into the state has been in excess of $120 million. So it's also been an economic engine within Idaho.
Another question for our panelists. How has the adjudication affected the social and political fabric of your state? Has the public interest been served? And we'll go in reverse order here. Clive, do you want to address that as well?
Anytime you have litigation, it creates conflict. And so throughout the adjudication, there have been some very heated battles, but in the end of the day, we generally end up with a settlement that's going to work for everyone. And I think the general consensus coming out of our celebration on August 25th was that it has achieved the desired outcome, not necessarily the way everybody would like to see it, but it's achieved an outcome that people can live with and provides a foundation for us to move forward.
Judge Lobo?
I'm probably the last person to ask that because judges live in a bubble. Everybody, in my experience, is always nice to judges, so I don't hear the bad things. And we're also at the way the adjudication works, we're at kind of the tail end of it. But the kind of anecdotal evidence that I can pick up, because I've been doing this for 23 years, and I attended, I don't know, 300 or 400 water user meetings. I've met with people from 1 person to 500 in a room. Sometimes they're a little hostile. But by and large, once we describe what we're doing and the purpose and where we're going to get to it, I have received very little adverse comments about our adjudication. I mean, they're unhappy sometimes, but I've only been reversed twice by the Montana Supreme Court in 23 years, and I don't know whether that reflects that they're happy or that they're just happy to get through the process and they're not unhappy enough to go to the Montana Supreme Court or to complain to their legislators about the adjudication. Plus, the legislature has been extremely supportive. In 2005, the legislature, we're having funding issues in the adjudication. The Montana legislature put a water user fee on every water right in the state to pay for the adjudication. And this was a fiscally conservative legislature that did this, and every water user group supported it, and it went through the legislature, 150 votes. There were maybe 8 dissenting votes in the entire legislature. Now, that's a remarkable thing. Now, they repealed it the next year when their constituents finally heard about it, but they also, at the next session, they then put $25 million into a fund for the adjudication. So I think, to me, all of those anecdotal evidence indicates that we have not damaged the social fabric in Montana with the adjudication. And I think most people, the water users, and one of the things we're doing is we're distributing water in accordance with our water court decrees, and we have water commissioners that are distributing water. So I think, from my little standpoint, that we haven't damaged anybody. You know, there are a few people that are unhappy, but by and large, most people think we're doing okay, I think. I hope.
John Weldon?
Well, I think you have to answer this question differently for the Gila adjudication than you do the little Colorado adjudication. In the Gila adjudication, none of the Indian reservations are checkerboarded. And so we didn't have the hostile relationships that Susan Williams described this morning existing in Arizona, but it wasn't a cozy relationship either. My client had been in litigation one way or the other with the Gila River Indian community for almost 100 years. And while they didn't particularly like each other, they weren't shooting each other either. And these water settlements have changed that whole relationship among the tribes and the non-Indian adjacent communities. The Salt River Project today is engaged in a variety of business relationships with the Gila River Indian community that would not have been available but for this settlement and the long time we spent together trying to negotiate a settlement and getting to know one another. And the same is true with some of the other tribes. On the other hand, one of our goals was to litigate and resolve the claims of all these upstream non-Indian pumpers above the reservoirs the Salt River Project operates on the Verde River. That hasn't happened, and that is a point of frustration in the Phoenix metropolitan area that exists to this day. On the little Colorado adjudication, there was a proposed settlement with the Navajos and the Hopis and the non-Indian users that collapsed a couple of years ago. And as a consequence, the non-Indian users that are all upstream of the Navajo and Hopi reservations continue to use some of the water resources of the Little Colorado River as they have been doing historically. And so they're kind of fat, dumb, and happy at the moment, whereas the Navajos and the Hopis downstream still don't have much development. There's no settlement in sight because the change in Congress's willingness to provide money for these deals. And the litigation is off to the races, and it's time-consuming, it's expensive, and it's a crapshoot. You don't know whether you're going to win or lose. And so in the Little Colorado, I think nothing has really improved in the grand scheme of things.
Yeah, I think I can frame it and generally in the state of New Mexico that, yeah, when these suits are filed, it causes great political upheaval and disharmony. And you hear about it from the legislature. And what do you need it for? Why do you want what this cost they're going to have to bear? Everybody's terribly upset about it. As you start reaching settlements, as rights get litigated, maybe the tone drops a bit, but then you start having the inter se process where you have largely acequias against non-Indians, and Indian tribes and pueblos, and then you start getting a different kind of political disruption. And you hear about that. But what I find ironic about the whole thing is where we have completed adjudications in New Mexico, and we have 12 completed adjudications, that's where you find the harmony. Where you don't have an adjudication pending, people are always clamoring for priority administration. When you have an adjudication pending, everybody's afraid of prior appropriation, prior administration, a priority call. They don't want to have their rights done. But where you have the water rights done and people live within their means, and they know we keep track of their neighbors who live within their means, there is harmony. They all get along, and you never hear about them. Of course, the legislature never hears about that because nobody's unhappy. So they only hear the third of the folks out there who are very upset about the process. So is the public served? Absolutely. They absolutely served in the end. The Judge Nancy Judge Guthrie, made the point, is there a cost-benefit analysis that will justify these? And I don't know that there is, but I don't think there's another way to approach them other than to complete the adjudication. Otherwise, you will have disharmony.
Thank you, DL. I've often thought that adjudications, like the stages of dying, you have to go through 5 stages of dying with an adjudication, leading to acceptance at the end. One final question for our panelists. It might be a strange question in Wyoming where you rely a lot on administrative agencies, but given the future of a lot of water-related problems that will have to be addressed, where, based on your experience, do you think decision-making should take place? Should it take place generally in the courts, like a permanent water court? Should it take place in administrative agencies? Or through some entities like these watershed forums or organizations that are sometimes convened by federal agencies? So we'll start with DL.
I'm actually excited to answer that question. I think Darcy Bushnell, who's sitting here from New Mexico, and I have been suffering through. There's got to be a different way to do this, and I've traveled to Idaho, Montana, Wyoming, Colorado. We spent money. The state legislature sent us out to investigate these other ways of doing adjudications. The problem is they want to change what's already being done, not what's going to be done. And so I think we're at a point in New Mexico where we need to go forward, and one of the things that's on the table that is a product of my staff and myself talking back when I was with the engineer was to have a rolling adjudication, maybe more like what Colorado does. You have an administrative agency who makes a determination on the water right, then you have it confirmed by the court. And when the court confirms that determination, then anybody who has an objection to it can come at that time and try to challenge the underlying right. That way, it's individual, because when we do water right applications and we license water rights, we don't have this social and political upheaval. You come in to get your water right confirmed, you come in and make an application to change it, and we quantify it. You might appeal it, but when it's done, and everybody goes on their way. And people live with that. And then the administrators in the office, the water masters, and who are out physically diverting measuring the diversion of water, they're able to do that, and people can live with that. And so maybe instead of doing these global adjudications where you sue thousands of people and you get this mob mentality, to do it in a more individual way, and also you're able to give the person who you've served or whose water right it is actual individual attention, so they feel like they're being heard and they don't get lost in the massive pleading litigation that these adjudications cause, where they're overwhelmed by documentation that they're never going to need for the most part. So there's a different way. I'm hoping New Mexico will pursue this other course to do the main stem. If you saw my map earlier, if you look at it, we really have the main corridor of the Rio Grande. It's sort of our Snake River that we have to do.
Well, Arizona has had several decree cases over the years, and every one of them has been entered as a consequence of a negotiated deal among all the parties. And I think that's the way these cases will eventually and need to eventually get resolved. How you get to that point, I'm not quite certain. We have what I would describe as a traditional litigation approach, where the Department of Water Resources does these hydrographic survey reports, and they evaluate each individual water user's water right. They're supposed to make a recommendation about what that water right is, and then everybody litigates against that target. Arizona doesn't have any real history of administration, and so the first rights that are subject to litigation, everybody's in there trying to establish a precedent for what's going to happen to them down the road. And it's caused chaos and a tremendous expenditure of time and effort and money by all the parties. It seems like the New Mexico approach, which I thought until just now worked pretty well, where the state engineer goes out and offers a judgment to a water user and says, here's our evaluate, and there's no real involvement by other parties at that stage of the game, as I understand it. Here's a judgment that you can accept or not, and then other parties can come in and object to the settlement if the party accepts it. I've always thought that would be a better way to do it, because I don't really care how much most people use. I care about how you got to that point, whether it's going to be used, some precedent will be used against me down the road in terms of how your priority was determined or how your quantity was determined or whatever. If there's no decision that describes all that, great. You can have whatever you can get, and I'm happy with it. So I think it's kind of a combination of the role that New Mexico plays and a negotiated resolution across the board.
Judge Lobel.
In Montana, the water court adjudicates the water rights. We hand our finished product to the general jurisdiction courts, our district courts, and they distribute the water using court-appointed water commissioners. And then if there is a change in, if there needs to be a change in the water rights, the claimants have to go to the Department of Natural Resources and Conservation. So you've got three entities that are dealing with the same thing, and there is some discussion, and Professor Michelle Mudd from the University of Montana is doing a study, and has done a study, on behalf of the Supreme Court as to whether or not that method should be changed. So in the next 2 to 4 years, we may actually see something like that change. It's the water users don't like to have to go to three entities to figure out what their water rights are and how to change them. So we may see some changes in Montana in the future.
Clive. Well, if you want to pay a lot of lawyers, you're going to go to a water court. If you want to get results, I think you have a combination or a hybrid system. And I think the system we have in Idaho has worked well for us. It allows pro se claimants to come in and represent themselves in a way that they don't have to incur the transactional costs of attorneys. And in many instances, they can't afford it. And so we can work out most of the issues before they go to the court, but we have the court as a backup system. So when we get to those disputes that we can't resolve, then they're referred to the court. And I would just argue our facts suggest that's a good result.
Thank you, Clive. We have 5 minutes. Maybe we could have perhaps 2 questions from the audience if there's interest in posing a question. Well, if not, join me in thanking this excellent panel, and we'll conclude.
All right. Mr. Thorson mentioned the kind of collective years of experience that were encompassed within the last panel. I'll only add that we should consider the collective miles traveled by those four gentlemen to here, central Wyoming. So please join me again in extending a round of applause to them. Yeah, deal. All right. That concludes our formal sessions for the first day. It's about 2:30. Concludes our formal sessions. There are two options for people going forward. One of them has been organized by the Northern Arapaho Tribe's liaison, Gary Collins, and the other for the law clerk of the 5th District Court in Worland, Gayla. And Gayla, forgive me for not knowing your last name. Gayla Mead, not a last name I should know, given that we're in Wyoming. Gary is going to talk a little bit about the field trip he's organized in a second. Gayla is going to then talk a little bit about the records review that she's organized as well. Again, these are two options for you how you can spend your afternoon going forward. Gary, if you talk first.
Thank you, Jason. It's so pleasing to see everybody here. I've been involved with the water issues and natural resources on the reservation here for some 20-some years. And it just has a lot of good energy here about everybody participating and talking about things at a different level since we're not in a courtroom. But anyway, as part of the program, the weather won't stop us, but it might diminish our enthusiasm to some degree. But there's a field trip that I've put together with Baptiste Weed and Jim Pogue and others out of the Tribal Water and Engineers Office. And what we're going to do is leave here in 2 buses at 2:45. The buses will be right out front. Use the facilities here if you can, because there aren't very many opportunities for rest stops, although in emergency base we probably could. But we're going to leave here and go 30 miles to the west, up 17-mile road, which goes through the heart of the Lower Wind River Unit irrigation project. And that unit is fed by water that's stored in Ray Lake and Washakie Reservoir and direct flows out of the north and south forks of the Little Wind River. But we will go up to a major diversion point called Ray Canal. And Ray Canal conceivably can deliver water up to about 25 miles. But that's not our regular recommendation, because towards the end of the ditch, it gets to be pretty sparse. So what I want to do is show you the new structure we put in at the Ray Canal diversion, and then explain what's going on there, and leave that site, which is just west of Fort Washakie, and go down and go past Sacagawea's grave site and go to Robert's Mission. And all along there you'll see the Ray Canal that I can point out in one of the buses along with some of my other colleagues. Then we're going to go down to Ray Lake. And we'll probably spend most of our time there answering questions, pointing out some features and some concerns that we have with regards to water storage. And then we'll move on down towards the southern portion of Ray Canal, where we did not have water last year beginning July the 17th. So we have some challenges in water management. We have some challenges with inefficiency of the system. And we have challenges when we don't always have the water in the snowpack. So on that one stretch of the Ray Canal, we have reserve water rights, state water rights. We have a variety of owners, tribal, non-tribal, fee ownership as well. So I hope to cover everything that we talk about in the legal arena and see it on the ground. And it'll be somewhat of a self-guided tour, because I'll be open for questions, as well as Mr. Pogue and Mr. Weed and any other tribal officials. Some of the water board might be there. Fred Tamanay is the director of that newly formed irrigation association, and he's making it work. Inside of his right pocket is a big bullwhip, and he does use it. But anyway, that's the scenario for the tour. Leave here, go 30 miles west, follow along Ray Canal, and then when we come back, we'll come back through Plunkett Road. And when I say 17-mile road and Plunkett Road, all those areas have irrigated lands provided by the water from the Washakie Reservoir drainage watershed. So with that, I'll let Gayla make her comments, but we'll meet out here at 2:45. In the front, there'll be 2 buses, and we'll be monitoring each bus. I'll be on one, and Baptiste and Jim will be on the other. So I'm looking forward to a good time. I don't know what the weather is. It's wet, but up at Fort Washakie, it might be snow. But if we can get out of the bus for a little bit, we can. If not, we'll just stay in the buses, and I can make those discussions. Thank you.
Okay, thanks to Ramsey. For those of you who are not taking the bus tour, but would like to go through a little bit of a demo on the website and how we've put together the documents, I will be doing that. One thing I would like to say, over the years I've had some interesting calls in this case, and one that I've gotten from people who are actually in this room but will remain nameless is, Gayla, I need a copy of the record. And for that, you need a Kinko's and a moving truck. So if anybody wants to see what we've done with that, I'll be doing that. We'll take a little bit of a break, and then just we'll kind of do it right down here, and you can get where you can see the screens.
So those are the 2 options. Field trip, embarking at 2:45 in front of the casino. For those who might want to look at some